Hello guys, finally welcome to expected questions marathon. Always we just give this expected question list that you can see over here, and based on this list you study. For the first time you can see all these markings over here. Basically I have finished the entire marathon and now I am recording a small quick introduction video so that you will understand what to expect in the next 2 to 3 hours. Okay, now sir, who should watch this expected question marathon, sir, and where do I find this PDF? Okay, very simple. You can go to the CA Classroom website, and if you go to the free resources, section, there you will find the expected questions PDF. I am doing this video after accounts exam. Those who have used this expected questions for accounts will know that topics like AS 10, AS 25, AS 28, consolidated P&L, everything is basically what we had in expected questions, and students are very happy. For law it's going to be even bigger, guys, with expected question marathon. Okay, what should you do? Sir, I already have this list with me, sir. Already have this list. I will study by myself using this list. Then you can leave this video. You can revise by yourself. This marathon is not for you. Sir, I am okay to spend 3 hours. I will dedicate 3 hours of my time to you. Let me revise expected question along with you in marathon. Then this video is for you, guys. By now you should know we have 3 marathons. If not, let me tell you. One is a 100% syllabus covered marathon, which is a 16 hours marathon. At this point you may not have time to watch this fully with hardly 1 day left for exam. So any specific topic, if you want detailed explanation, go watch that. Link for that is in description. What I will strongly recommend, I will say even better than my expected question marathon, I am not simply saying that, is the 100% syllabus covered, which is nothing but the GENZ marathon, guys. In 4 hours it's a killer where entire syllabus is covered. If you need something, I want 100% syllabus revision, sir, go watch the GENZ marathon. Okay, in this video, in this next 2.5 hours, we are going to revise only these expected questions where I will tell you which is important, which is not important. For that, this video in the next 2 to 3 hours, we are going to have expected question marathon where you will revise with me and keep a book with you and keep learning. Final thing, in this expected question marathon, sir, we have 15 chapters, but only for few chapters I have directly linked you to GENZ, meaning not that I won't discuss here, I will briefly discuss here, but detailed I am pushing you to GENZ, like meetings, auditors, a few concepts, books of accounts, only CSR, rest everything is there in this video. And in FEMA I have done a full brief but detailed explanation in GENZ, just to save some time for you guys. Okay, and I want you to experience GENZ also for that reason. So now that's it, I don't want to waste more time. Go enjoy the expected question marathon. And if you are someone who has watched either the GENZ marathon or the expected question marathon, or both, just like law, I just need one request from you. I'm not going to ask you to subscribe to channel, guys. You would have already subscribed to the channel, that's fine, but I want you to comment how it was, how helpful was it for you before the exam and after the exam, how helpful for you it was, so that I will know, okay, this is good, these are the things I have to change. Next time for your juniors I can do better. Those small feedback messages from you make my day, because I am recording this today after your accounts exam at 10:08 p.m. Around 11 p.m. you will get the video, guys. So for that, those small messages will help us, guys. That's about it. Thank you. All the very best. Any doubts, WhatsApp me. Tomorrow full day I will be available to reply to your chats, guys, or in the comments I will reply. Enjoy the expected question marathon and go, like usual, ace your law exams. Hi guys, welcome to the expected question marathon revision. Let's start off with preliminary chapter. First is associate company and small company, guys. Over here if you go and see, first small company, what is important? Paid up share capital should not exceed 4 crores and turnover should not exceed 40 crores, but that 4 can go up to 10 crores and 40 can go up to 100 crores. Come down, let's go for associate company. In associate company, what is the important definition? Over here they are saying it should have significant influence. Significant influence means they are saying 20% of the total voting power. But people leave this only with 20% of voting power. No, there is another point. So significant influence means I have 20% of the voting power of that company, or you have control of business decisions under an agreement. That means even if my voting power is 0, if you are controlling business decisions under an agreement, then it will become an associate company. Are you following, guys? Here they are saying 20% or more of voting power. It's not paid up share capital. Very important to note over here, guys. One more important thing to note over here is it includes equity share capital and also convertible preference shares. Many people forget over here. Next, the expected question in preliminary chapter. So associate company, they will test straight away definition or a case study, or small company limits of 4 and 40. When comparing in exam, compare 4 and 40, don't compare with 10 and 100. Next, listed company and what is not a listed company, guys. First they are saying listed company is any company whose securities, they don't use the word share. So securities can be share or debentures which is listed, then it becomes a listed company. Even if one is listed, sir, debentures listed, sir, shares are not listed, still I will call this what, guys? Listed company only. Then they are saying, look at this, which are listed or in the process of listing, no, is not a listed company. Very important. Application for listing is made but not yet listed. So in the process of listing is not a listed company. Important point that can come in exam. Then if you come down here, they have given a list. They have given a list as to what is not a listed company. Look at this. The following are not listed companies, even though their securities are listed on the, like if they listed on the stock exchange. Look at this, what they are saying, which have not listed their equity share. So equity share is not listed, but look at this, equity share is not listed, but instead what did they list, sir? They listed non-convertible debt on private placement basis, non-convertible redeemable preference shares on private placement basis, or both. So if you see terms, look at for cumulative condition, equity shares are listed panla. Instead of that, what they listed, non-convertible debt or non-convertible redeemable preference shares both on private placement basis, then this is not a listed company. Additionally, private companies can never be called listed companies even if they listed their non-convertible debt. Sir, why is this point important? Look at this. For other companies, if debentures is listed, it's called a listed companies. But for a private company, if their debt is listed, if debenture is listed, it is not a listed company, guys. And lastly, of course, public company which is not listed is not a listed company, and they are defined unlisted company and other than listed company. So this exception list is very, very important. I hope I have covered all the points. Okay, next, startup company and dormant company, guys. Look at this. Let me go to startup and dormant. If I take the definition of startup company, not tested so far, but very important, it has to be a private company. First, it has to be a private company, and it should be recognized under the government, and they should obtain a DPAAT certificate. How to get this? You have to get this in Department of Industrial Policy and Promotion. That only is called DPAAT, Department of Ministry. From there you have to get a certificate. And startup company can be startup only for the first 10 years. Beyond 10 years, it's not a startup, and turnover of that company should not exceed 100 crores in the preceding financial year. That means if I am now in the 5th year and my turnover is 96 crores in 4th year, you can be called as a startup. Sir, I am in the 7th year now. My 6th year turnover is 101 crores. No, you are not a startup. I can apply and become startup in any of the first 10 years. Okay. Next, let's go for dormant company, guys. Important one. Important. Of course, all these are important concepts. Now, if I take dormant company, sir, what is this dormant company? Very simple. Now, dormant company are companies which do not do major activity. They are incorporated for certain projects, like for a future project or to hold an asset, just the asset in company's name, or intellectual property. Elon Musk for Neuralink, intellectual property is there in dormant company's name, and they do not have any significant accounting transactions. Sir, this part I get confused. in simple, they have given 4 points. These 4 points you can do. These 4 points can be done, but beyond these 4 points, other things cannot be done. Okay, what are those 4 things? You can pay fees to the ROC, like payment of fees, charges or ADT, auditor appointment, those kind of fees. Any other law, PF, Factories Act, those payments. Allotment of shares is mandatory, that you can do. And payment for maintenance of office and records. If a company means office is mandatory, not virtual office. Physical office is mandatory. So if office is there, I need to pay rent, all those payments. So that's it, guys. This is a dormant company when the company is incorporated. Sir, other companies can become dormant company. Yes, if company has not filed annual return or FS in the last 2 financial years consecutively, if they have not filed, it becomes a dormant company. Sir, year 1 I filed, year 2 I filed, year 3 I didn't file, year 4 I filed, year 5 I didn't file, then it's not a dormant company. They're talking about it for 2 years. If they have not filed in the last 2 financial years, then it becomes a dormant company. Okay, let's proceed to the next concept, guys. Holding and subsidiary concept along with public financial institution. Let me go to that. Now, what is public financial institution? Very simple. Public financial institution is a combination of what do you call statutory company plus government company definition. So what is statutory company definition? It's established under a central or state act. There is nothing but special act, and they use the word and at least 51% of paid up share capital is held by central government or state government or combination of both. Let me know in the comments whatever doubts you have, guys. I will be here. I will keep responding to you in the YouTube live itself, okay, or later in the comments also. So combination of central, state or both. Next, sir, what is this holding and subsidiary company? For holding and subsidiary company, 2 primary conditions: has more than 50% of voting power, or here it's not and, or controlling composition of board of directors. This all of you know, guys. This all of us know, sir. What is new in this? But here it is, or controlling composition. You have the power to appoint, remove, decide what the board of directors does. Okay, now here 50% or more, either on its own or together with 1 or more subsidiaries. This includes, for example, if A plus B plus C together they have 60% in D, okay, and this A, B and C, X is having 70%. Look at this, guys. X has 70% in A, B and C. A, B and C together has 60% in D. Then X becomes holding of D because indirectly it controls more than half of total voting power. Fine. This is how I know, sir. Now the next exception in this section 19 is, they have asked this in September also. Jan they didn't ask. Maybe it can come in May again, because in September many students made mistakes. Subsidiary company cannot have shares in holding company. There are 3 exceptions. We all know that subsidiary cannot have, but what are the 3 exceptions, sir? One exception is they were already a shareholder, or you were a trustee, holding it as a trustee, or you are holding it as a legal representative of deceased member. So what? Okay, in this case, already a shareholder now, you cannot vote. You cannot vote if you're already a shareholder. But if you're a trustee, you can vote, and if you're holding as a legal representative, you can vote. This is the important point. Sir, what is legal representative? For example, in the holding company, Michael Jackson is a shareholder. Now Michael Jackson died, therefore his legal representative is the subsidiary. Subsidiary can hold shares. Are you getting it, guys? Same way for this trustee also. Look at this. For example, Vijay Mallya is author of a trust. For his son, he created a trust, and his trustee is taking care of all the assets. Now when Vijay Mallya dies, his shares will be taken care by the trustee. Now if this trustee is the subsidiary already of the companies in which Vijay Mallya is there, you can still continue to hold shares because you are holding it on behalf of Vijay Mallya, guys. I hope you're getting the clarity over here. These are the points over here. Let me proceed to next one. Yeah, one person company, guys. Now if I come to one person company, on top. Yeah, in 1% company, very important for your exam over here. First, let me break this down into 15, 30, 120 and 180 days. There are 4 time limits over here. Sir, what is 15 days, sir? If a nominee leaves, you have to appoint new nominee within 15 days. Sir, what is 30 days, sir? Very simple. If there is a change in nominee, you have to intimate ROC within 30 days. Sir, what is 120 days? Every member and nominee of 1% company should stay in India as a resident for at least 120 days in the previous financial year. That is 120 days. Sir, what is 180 days, sir? 180 days, sir. Very simple. If you become member of 2 OPCs, you should decide which OPC to continue within 180 days, within the next 180 days. These are the 4 points. Sir, what are other key points in 1% company chapter? Of course, it's a separate legal entity. Then I can start maximum only 1 OPC. So you can be member of 1 OPC and nominee of another OPC only, guys. Next, being citizen is important. Residentship shares, they only count 120 days. That is enough. Okay. Then 1% company can be converted to any company except Section 8 company, and 1% company cannot invest in securities of other companies, but it can invest in NBFC. These are the key provisions in 1% company points, guys. Okay. If you want to convert OPC to private or public company, very simple. Increase the minimum number of members and directors, then increase the paid up share capital, file to ROC with all these attachments, MOA, AOA, resolutions, list of creditors, etc. and then they will issue a new certificate of incorporation. So these are the concepts in preliminary chapter which are there in our expected question, guys. I hope you got a brief rough revision. Additionally, you also learn about Nidhi company. Nidhi company doesn't come here, it comes in other chapters, small points. Anyway, for Nidhi company, I will be sharing a separate video with provisions of Nidhi company one day, tomorrow itself, guys. Let's move on now to the next chapter. Now let's go to incorporation chapter, guys. In incorporation, if you see section 3A, unlimited liability, little important. What is this talking? Small points I'll explain here itself instead of going to main material just to save time. Unlimited liability says if the number of members for a public company falls below 7 and a private company falls below 2 and business is carried on for more than 6 months, then the liability of such company will become unlimited for that period. That means within 6 months they have to rectify that, otherwise liability will become unlimited, guys. Next, name clause related concepts. Here very simple points. If you are going to apply for a new company, the name, once you apply for name is reserved for 20 days, guys. If you are applying for an existing company, name is reserved for 60 days. Now, so why the difference? The only point here to catch is, for existing company you are getting 60 days at once, but for a new company you get only 20 days. But here the important catch is, if you want you can extend and get additional 20 days and again get additional 20 days. That means overall in both is 60, but for a new company first you will get 20, you can pay extra, get more 20 days, again pay extra and get more 20 days. This is name clause related reservation concept. Here other points, be very careful. Here there's another important amendment over here. The name of the company should not be identical to other companies, but the name of the company can be identical to other partnership firm. This point is there mainly in LLP than Companies Act. Okay. Next, section 10A, which talks about commencement of business. Sir, what is this commencement of business provision? Very simple. Once company gets certificate of incorporation from the date of incorporation, within 180 days they have to file 2 things to ROC. They have to file 2 things to ROC. File with ROC verification of its registered office. Here many people get confused. Sir, we have to file this in 30 days. No, sir. No. Within 30 days of incorporation, company should establish the registered office, but that registered office details should be filed to ROC within 180 days. Along with this, what they should file, when you incorporate the company in MOA, initial shareholders subscribers of MOA, so those people should give a declaration, and also other directors, that all the shares that they have undertaken by them has been undertaken and money also has been received in the bank account. So two important things: verification of registered office, declaration of the first subscribers of MOA that shares have been allotted, guys, and of course this should be verified by CA, CS and CMA. If not, what is the default? You will have a look at the default at your end, guys. Next, already again I'm giving here 1% company. We already spoke about this in just now in preliminary chapter, guys. Next, let me go for doctrines, different kinds of doctrines. We have 3 different type of doctrines. Let me take all the doctrines in our material itself. Okay, what are the 3 doctrines we have? We have doctrine of constructive notice, we have doctrine of indoor management, and we have doctrine of ultra vires. Ultra vires is there, guys. Now what is ultra vires saying? Very simple. Company can do only what is there in the object clause. If you do anything which is not there in the object clause, then that will be void ab initio, that will be void. That means if you want to do something, first you have to amend the object clause and then only perform that particular activity. Can this be ratified? No, this cannot be ratified. So this is doctrine of ultra vires, guys, which we have just now completed. Okay, yeah, this is doctrine of ultra vires, which just now, yeah. Now let's go for next one, doctrine of construct notice and doctrine of indoor management. What are they saying over here? Look at this. Doctrine of constructive notice says the outsider is deemed to have read all the documents of the company, public documents like MOA and AOA. He has understood everything. If he has not read and not understood, that is not the fault of the company. So doctrine of construct notice is defense for the company. Sir, where will this come? This will come in section 81 in date of notice of charge. Third party is having the, company believes that third party has read and understood if company has taken any charge. Otherwise, company is not responsible. Connecting between these 2 chapters. Exception for doctrine of constructive notice is only doctrine of indoor management. What is this? Now, third party is saying, I know, sir, company internally they should have passed all the resolutions, but have they actually passed the resolution? For example, company's AOA says company has to pass a board resolution to obtain a loan, but have they actually passed the resolution and obtained the loan? As a third party, I can't see in the company. Therefore, they are saying this principle lays down that what happens internally in the company is outside the purview of third party. Therefore, he should be aware it should be passed. Whether it's actually passed, I don't know. Therefore, doctrine of indoor management, what happens indoor, not my responsibility. Defense for third party against the company. Now, this doctrine of indoor management has some exceptions. What they are trying to say in exceptions over here, I know they have to pass board resolution, sir, but I know they didn't pass. I can't be silent. Look at this. Knowledge of irregularity. When you know something company has to do, but they have not done that, you can't take the exception of doctrine of indoor management. Go to the exception to exception, which is exception to above. It's also known as Tarkan rule in exam. Knowledge of irregularity, or also suspicion of transaction. I have a doubt if they did or not, then I can't take benefit of indoor management. Therefore, again, this becomes defense for company. So basically, if you see here, constructive notice, defense for company. Indoor management, defense for third party. Again, exception to indoor management is defense for company. Knowledge is suspicion, and forgery. If forgery happens, third party or company is saying we are not responsible, forgery is done by watchman, etc. Or doubt only is suspicion of transaction. Are you following, guys? So these are the main points in doctrines. They have not tested these doctrines for a long time. That's why I mentioned here as long pending. Next, alteration of articles and entrenchment provision. Sir, how to alter articles, sir? Articles can be altered by simply passing a special resolution. Now, very important, if you are converting from private to public company, remove the restrictions of private company like maximum 200, all of that. Simple procedure. But converting from public to private, the process is a little more strict, Here they are saying, along with the special resolution, you should also get permission of regional director, guys. You should get copy of central government in case of public to private. So public to private, you have to get the permission of the regional director. Are you following? Is very important because public is becoming private. Okay, what is the following procedure? Converting from public to private. When you are getting permission of regional director, you have to give the following attachments: MOA, AOA, copy of minutes where SR is passed, copy of board resolution, declaration by KMP. Now coming to entrenchment provision. Sir, what is this entrenchment provision? Generally, what is the most strictest thing in Companies Act is special resolution. If you want to keep something much more stricter than special resolution, that's called an entrenchment provision. I hope all of you are following. Sir, when I can keep entrenchment provision? You can keep entrenchment provision at the time of incorporation in the company formation in SPICE form when you attach articles AONO. That time I can keep, or it can be altered subsequently. For private company, you have to pass unanimous resolution for alteration. For public company, special resolution is more than sufficient for altering the entrenchment provision. That means if you want to add or remove an entrenchment provision for a public company by passing special resolution, it is more than sufficient, guys. Let's go back to our list. Yeah, alteration is done. Now we only have two more concepts, point number 3 and point number this last one, 20, 21, 22. Let me quickly complete that. Last 3 concepts they have tested many times along with Nidhi company. Along with Nidhi company, one exception we have over here. So let me take that over here. 20, 21, 22. What is 22 saying? Every company has negotiable instruments like bill of exchange, promissory note and check. Who will sign this? If company is having common seal, sir, company has common seal, then common seal will be used. Sir, company is not having common seal, sir, then company is having CS, our CS is that, no, our friend called the CS. CS plus director will sign it, guys. Sir, no CS also, sir, then 2 directors. The same thing is also there in section number 46, where we talk about share certificate will also be signed by the same people. Simple, common seal, use common seal. Not there CS plus director, no CS 2 directors, that's it. Sir, now who will sign this? Who are these directors? Who can use this common seal, sir? Watchman can use common seal? No, they are saying authentication of documents is section 21. Who can authenticate rental agreement, contracts for company? They are saying it should be done by key managerial person or any person who is authorized by the board. Who is KMP? All these people you can see here, CEO, MD, company secretary, whole time director and CFO, or any person who is one level below directors and in full-time employment designation. In contract letter they should be having, or employment letter they should be having KMP over there. This is 20. So 22 is what? 22 is execution of negotiable instruments. 21 is what, guys? Authentication of documents. And 20, serving of documents. Sir, what is this? If ROC wants to send something to the company, or if company wants to send something to ROC or members, sir, what is this? What will ROC send to company? Notice, you are not filed this, give me explanation. What will company send to ROC? Reply. What will company send to members? Dividend warrants. Like this, if company has to send something to ROC, or if they have to send, how they will send? Registered post, speed post, courier, or leaving at the registered office, or any electronic mode like email, WhatsApp. The same thing. Additionally, when company is sending to member is saying I don't use WhatsApp, I want Telegram, or I want Signal app, or you send me Instagram DM. If any member specifies any specific mode, you send in that mode, and if for that if there is any cost, you can recover that cost. Very simple. If it is going to be in DMAT depository, then electronic mode is sufficient. This is section 20, serving of documents. Can I amend this? Yes, you can amend this, but it should not cross section 6. That means it can amend within this, but you can't remove. Registered post not applicable for my company, courier not applicable for my company. That you can't change, because Act will override AOA and MOA in section 6. So Act is saying you have to allow speed post, allow courier. Where it is electronic mode, they are saying only if it's in DMAT format, that case electronic mode is fine. Sir, what is this Nidhi company exception? We have separate video for Nidhi company exceptions, but here quickly in this section they are saying if the document which I have to send to Nidhi company, I will send it only if the members are having 1000 rupees or more in face value, or 1% of paid up share capital, whichever is less. So if somebody is having 800 rupees face value or less than 1% of paid up share capital, I will not send it to him. He has to come and see. So for other shareholders of Nidhi company, document may be served in public notice in newspaper. So I will anyway put in newspaper, you see it over there. When I will send you the notice letter to your house, if you have more than 1000 face value or 1% of paid up share capital, whichever is less. Any notice, for example section 136, circulation of FS. When a Nidhi company is circulating FS, follow these provisions. I will send only if face value more than 1000 or paid up share capital 1% or more, whichever is less. Any one you should satisfy. Okay. So this we will come back. I am done with alteration, all these points. Last concept, alteration of situation clause not tested for a very long time, guys. Shifting of registered office. When it comes to registered office, first things, within 30 days of incorporation you should establish this. Labeling point, important, especially in this COVID world and online world, virtual office not allowed, it has to be a physical office only, guys. Now come here, shifting of registered office within same city, sir. I am in Chennai, within Chennai. I am in Mumbai, within Chennai. No need to ask shareholders. Board resolution, intimate ROC in 30 days. Sir, within the same state and same ROC. I am in Tamil Nadu but within same ROC, Chennai. I am in Andhra, same ROC, Vizag. Then pass SR, get members approval. Of course you also have to pass board resolution and special and intimate ROC within 30 days. Outside local limits of city town. These two are the easy ones, guys. Easy peasy, easy ones. Next two, state to state, and this is very unique, practically possible only for Tamil Nadu and Maharashtra. Within the state, but within the state different ROC is one procedure. One state to another state another procedure. These both have not been tested for a very long time. Quickly go through these at your end, guys. I have given the list over here. Okay, I have given the list over here how this will happen, but let me share some common points for both. The process is very simple. In both the cases we will file to regional director, then regional director will give the approval. That approval you will file to ROC and you will get the new certificate of incorporation. Sir, why should I get new certificate of incorporation over here? Very simple, because new certificate of incorporation, because the registered office is changing, address is changing. So simple, file to RD in both, regional director, wait for approval and then ROC will grant or inform the ROC. When you are filing to RD, few points are common in both. What are the few points which are common in both? You have to give some declaration that payment to workmen there is no due. You are getting consent of creditors. The company must tell there is no change of court. Whichever court I am already there, I want to continue in the same court, and copy of intimation from the chief secretary. These are common. This is from within the same state. If it is going to be state to state, along with workman permission, creditors permission that they will not be retrenched, court approval and chief secretary. Additionally, you also have to get consent of debenture holders. So state to state, additional debenture holders. Here within the state, no need debenture holders permission. Here the time limit is 30, 60 and 30. What do you mean 30, 60 and 30? When I say here within the same state. So once you pass the necessary special resolution, apply to RD within 30 days. RD will give you approval and then within 60 days you will get approval and then you will intimate ROC within 30 days. Coming to the next one, it is going to be a rule of 30 to 60. I would have given over here. Yeah, it's going to be a 30-60 rule. This timeline alone you go through, guys, because I want to keep this marathon very short and only focus on what are the important points. So with this we are done with incorporation chapter. Let's go for the next one. Let's now go to prospectus chapters, quick revision, guys. In prospectus, first let me finish shelf prospectus and red herring prospectus for all of you. Now what is shelf prospectus, sir? Very simple. Shelf prospectus is one which is issued with a validity of 1 year. So what are the key points here? Validity is 1 year. During this 1 year you can do multiple issues. For any multiple issue you have to issue something called information memorandum, which gives the updates from the original prospectus. That should be given 1 month before shelf prospectus is given. This information memorandum will contain important details like change in financial position, any charts created, any other material information regarding the company. If any investor gave money in advance, calls in advance, he can claim refund and that should be given to him within 15 days. And this 1 year time period starts from the date of the first offer. These are the key points in shelf prospectus, guys. Red herring prospectus is nothing but a prospectus where quantum of shares, that means number of shares, 10,000 shares into 70 per share, 10 rupees face value. So basically the quantum 10,000 or price per share 70 rupees per share or 60 per share is not there. Basically by issuing prospectus, doing a book building process, we will figure out what is the price per share. Now what is the key point here? RHP will be given prior to issue of prospectus and RHP will be filed with registrar at least 3 days before the subscription offer is being made. These are the two key points over here. Once the RHP is issued, you will issue the final prospectus, and if there's any difference between RHP and final prospectus, that should also be highlighted and given to ROC. So we are done with shelf and red herring prospectus. Let's go to definition of promoters. Important definition. If you look at definition of promoters, guys, who is a promoter? Somebody whose name is mentioned as promoter in annual return or prospectus. So in annual return of company or prospectus, his name is mentioned. Rahul is promoter, or that person has control over the company directly or indirectly, or in accordance with whose instructions the board is accustomed to act. Basically the second and third point, guys, is nothing but your holding and company. So somebody, if you have like some control, like holding control on the subsidiary, like that, if you have control over the company or composition, board is accustomed to act, means you become promoter, or name is mentioned in annual return or prospectus of the company. Done with promoters definition, guys. Now let us go for the next one, fraud. Limits alone you just have to be little bit aware over here when it comes to fraud, guys. Fraud comes in many cases. In all these cases wherever fraud comes, be aware of penalty, because there is one case where they can test with penalty. Involves public interest, does not involve public interest, penalty is given. Just run through this. What is the fine, what is the imprisonment in both these cases? Fairly important for our exam. Next, deemed prospectus and underwriting commission. Let me quickly finish these points over here. Underwriting commission. What is underwriting commission over here? In case of equity shares, the commission is 5%. In case of debentures, it's going to be 2.5%, or rate mentioned in articles, whichever is lower. That means the maximum is 5 or 2.5%. Sir, for paying underwriting commission, can I use proceeds of issue or can I use profits of company? You can use both. You can use proceeds of fresh issue or you can use the existing profits also. This is with respect to underwriting commission, section number 40. It should be given only if articles is authorizing the same. Sir, what is deemed prospectus? Very simple. In certain cases, in section 25, some companies want to evade this chapter, so they will try to escape by issuing something called a deemed prospectus. So what is this deemed prospectus? Let me explain, guys. So if I take section 25, deemed prospectus, yeah, here we go. Yeah, before that, let me just take off the other sections. Let me take this DMAT and 28 offer for sale also. I will finish because it's right here. Yeah. 29 talks about DMAT. Sir, what is this DMAT? All securities of all companies have to be in DMAT form before making public offer. If it is not in DMAT, what is going to be consequence? The consequence is company cannot make buyback, company cannot make bonus, company cannot make rights, or company cannot make any offer of securities for a public company. So it has to be in DMAT. What are the key points in section 29? Every year you have to pay fees to depository because they are maintaining your shares in DMAT, and you should also give security deposit of not less than 2 years should be given with the depository. Next, every year within 60 days of conclusion of each half year, company has to file PAS 6 to registrar certified by a CA and CS in practice, and some shares will be in physical, some will be in DMAT. So every year the difference between issued and shares held in DMAT shall be filed with depository. I can do the same marathon with our Gen Z notes, but for Gen Z we already have a 4 hours marathon. That's why I'm doing it with our regular notes, guys. Okay, so difference between issued capital, how much is in DMAT, how much is in physical shares should be filed every year, and PAS 6 will be filed within 60 days of conclusion of each half year. That means you have to file it 2 times every year to ROC. You have to keep filing this, guys. So these are the points in DMAT. If there's any grievances, then you can go and file it with SEBI. These are key points in section 29, which is DMAT. So what is 28? Offer for sale. In offer for sale, it is nothing but in offer for sale means I am not issuing shares newly to public. The company, from existing shareholders, I will collect the shares and give it to new shareholders. If I am the company, there are some old shareholders, there are some new shareholders. From old shareholders, I will take shares and sell to new shareholders, collect money from them and give to old shareholders. I am like an agent or broker over here. Here they are saying few things. For doing this activity, I have some expense, so that expense will be reimbursed. All provisions related to contents of prospectus like section 26, liability for misstatement 34 to 36 are equally applicable here. All provisions like minimum subscription, minimum application value, that 5% of nominal value, 90%, all these are not applicable for the company, which cannot be complied, because I can't expect minimum subscription over here. Therefore, point number 4 says what is applicable. What is applicable? Contents of prospectus, criminal and civil liability applicable. What is not applicable? Minimum subscription, minimum application value, these are not applicable. Rest, they are saying however you do this, however company issues document to the new shareholders and existing shareholders, this will be called as a deemed prospectus only. Sir, now what is deemed prospectus, sir? Sometime back you spoke about it. Now what is deemed prospectus? Look at this. Sometimes what happens, a company, let's say company X, company Y, and then public. Okay. Now company X, instead of getting money from public directly, they will enter into an agreement with company Y, and this company Y will issue securities to public. From public they will collect money and Y will give it to X. So this agreement between X and Y, what is special between the agreements? Between X and Y, the agreement is such that X's shares, X or a share is given to public through Y. This becomes a deemed prospectus. So that is only this agreement between X and Y. Sir, how do I know it's deemed prospectus? They are saying two important conditions. If any one is satisfied, I will call this as a deemed prospectus. What is that? Company enters to transfer securities to allottee. X is transferring shares to Y and they are issued to public within 6 months from date of agreement. So from the date of agreement between X and Y, the shares are given to public within 6 months, or the allottee is Y, guys. The allottee has not paid full consideration to the public. So allottee has not paid full consideration back to the X. So two things. The moment agreement is made between X and Y, within 6 months allottee is issuing shares to public, and second, consideration from Y is fully not paid to X. If any of these are there, it becomes a deemed prospectus. All other provisions of the chapter is applicable. It should also be signed by 2 directors in case of a company, and partnership form also means partners have to sign. So what are the important points, key words to remember, guys? Company enters into agreement with allottee X, issuing house, to transfer securities, shares to allottee, and such shares are issued to public within 6 months from date of the agreement. Are you following, guys? Issued within 6 months. Or allottee X has not paid full consideration before the sale to public. Anyone satisfied, na deemed prospectus. What I have highlighted here is the key word that you have to memorize, guys. Next, I am done with shelf prospectus. Fraud, I told you, deemed. Underwriting, DMAT, offer for sale. Next, new additions 33 and 38, we will come to that. Before that, criminal and civil liability, guys, very important. Mostly see you in exam means it is going to come in exam. What is 34 to 36? Here they are trying to say, look at this. In case of any prospectus where there is any statement which is misleading, I told something, misleading means mentioning something which is wrong, or omission, something that I have to tell is not there. Keywords important, I am explaining in own words, but still keywords important. Something is misleading, or what is supposed to be there is not there, then the person is liable under 447, we already saw. What is the defense? For you to escape, you have to prove that that statement or omission, what I told which is wrong or what I omitted is immaterial, or I have to prove that I thought it was true or I thought the omission was necessary. This is 34, criminal liability. Civil liability is very simple, sir. What is the civil liability provision saying? If because of your wrong, fraudness, any people, if they have suffered loss, then all the people who authorize the prospectus, who are all the people? Promoters, directors, expert, every person who has authorized the prospectus, directors existing and proposed directors, you all are liable for all the people who have sustained loss. If it is defraud intentionally done, liability will become unlimited, guys. What is the defense? There are 4 defense over here, but basically if you have signed and then later you realized you made a mistake, first this issue you have to withdraw the consent. I want to withdraw my consent, or you have to prove it was issued without my consent. Either I gave consent or I will withdraw, or second it's given without my consent. Next, if I was depending on the report of export, I signed because export told this, then I am not liable. Export only is liable, so I am not liable, export is liable. Lastly, later if you want to withdraw, then you have to withdraw before the allotment, okay? Or you should tell, I thought it was true and believed it to be true until allotment. You have to prove why you felt it was true. Somebody convinced you. So what are the 4 points? Either withdraw, or tell I didn't know it happened, it was given without my consent, or I relied on the expert, or I thought it was true, therefore I stuck to whatever I said. This is 35. Criminal is arrest 447. 35 is full liability you have to pay. 36 is talking about what, guys? This also is there in our expected question list. Come back here. Yeah, criminal 34 and 35. That's all we finished, guys. 36 you go through later. I'm only revising expected questions over here. 36 also is important, guys. Okay. Basically, let me, since I marked, let me just say, if any person makes you get credit facility from bank, or makes you enter into an underwriting agreement, or makes you they earn profit through some price fluctuations, which is deceitful by giving wrong information or wrong forecast, that person is liable under section 447. Now let me go to the new additions in this chapter. So what are the new additions, guys? 33 and 38 new additions. First new addition is section number 33. In some cases, abridged prospectus is not needed. Newly added, very important for exam, when it is not needed, sir. In case of the following 3 cases, underwriting means not needed because parties are very small. Rights issue, existing shareholders, so not needed. Or if it's not issued to public within our existing members, mainly for private company, then it's no need to issue. What, guys? Abridged prospectus not needed, guys. Prospectus needed, abridged version is not needed. Underwriting rights are not issued to public. What is section 38? Another important section. Sometimes some people, what they will do, they will fraudulently change their name. My name is Karthik Manikonda. I will do Manikonda Karthik, KM, MK. I will keep changing and apply in multiple names, so I get the share allotment. So or if I am not Karthik Manikonda, I am trying to say I am Karthik Manikonda, fictitious names, creating fake names, let's say Zabar, Rubar, or some fake name, and doing, then also what will happen? This section 38 will come. What is section 38 saying, guys? Quickly. So what is section 38 saying? Very simple. Look at this. 38 says, if you apply in fictitious name, fake name, or multiple different combination of surname, or induces a company to allot to a fictitious name, Zubar, nobody is there, simply allotting his name and fictitious name, then you are liable. You are liable. All the gain that you get has to be refunded. You are liable as a shareholder. Therefore, this is punishment for personalization of acquisition of securities. This is section 33 and 38. With this, we're done with prospectus. Let's go to the next chapter, guys. Okay, let's start off with revision of expected questions for share capital now. In share capital, first is what, guys? Alteration of share capital. In alteration, what are the key points, sir? If you are going to increase the authorized share capital, you have to pass special resolution. But for all other things like consolidating, what is consolidating? 1 lakh shares of 10 is becoming 10,000 shares of 100. Reducing the quantity, increasing face value. Or subdivide. 1 lakh shares of 10 will now become 10 lakh shares of 1. And other 2 things, converting share to stock, stock to shares, and cancellation of shares which have not been taken up by any person. Unsubscribed shares which I am cancelling. For these 4 cases, it is enough if you pass an ordinary resolution. But here they may ask direct, but they will ask case study. What do I mean by case study over here? For example, they will tell a company's share price is not going up. How to create demand for the share price? I have to do subdivision, increase the supply of shares, or I want to reduce the supply of shares, then you will do consolidation. So case study based questions can come over here. Next, let me go to next question after 61 over here. Rights issue, amendment points, and bonus issue. Rights issue, if you see quickly, what are the key points? First, the company has to pass what, guys? Special resolution has to be passed over here, and board resolution for rights made to existing shareholders. Now once I make offer to existing shareholders, they will have time to accept. Minimum 7 days and maximum 30 days will be given. In this time, either they can accept, or they can reject, or they can renounce. That's what I have given over here. Look at this. They will have time to accept, reject, or renounce. Okay, accept, reject, or renounce the offer. So what if the shares are rejected? Nobody subscribed to this. The remaining shares will be unsubscribed by a company in a manner which is not disadvantage to the existing shareholders. Then they are saying the shareholder should at least receive letter of offer 3 days before opening of the offer. 3 days before offer opening, he has to get an offer should contain some basic details. I'm only running through the points over here, guys. Of course, it's a marathon over here. Now, sir, I'm renouncing this to somebody else. No, sir. Whom I can renounce, sir? You can renounce this to anybody, not necessarily existing shareholder. I can renounce this to existing shareholder, or I can renounce this to anybody else also. These are key points in 62 what they can test. Next, if you're making rights to employees, I can make under ESOP plan. You have to pass SR, and listed companies now other procedures should be followed. Outsiders means DMAT, just like a private placement. Here two important sub points I want to discuss: 62 subsection 3 and 62 subsection 456. This is 62 subsection 3 is a case where company has issued debentures or loan, and we have not repaid debentures or loan. So such debentures or loan will be converted into equity. Will be converted into what, guys? Equity. If for this, when I will convert, if the interest is not paid or terms and conditions of loan or debenture is not followed, for this first you should have passed special resolution. What is 62 subsection 456, sir? Same loan or debentures I took from government, sir. Even if you are paying interest on time, or if you are not paying interest on time, government doesn't care. What government will come? Government will say, if the company is operating in such a way, or the terms of issue is not for public interest, is against public interest, then whether interest is paid or not, irrespective of the financial, of course they will see financial position, such loan will be converted to equity. Will be converted to equity. Very, very important point over here. This will also lead to increase of authorized share capital. Meaning, if paid up share capital is 100, authorized share capital is 150. Okay, and if loan is 300, conversion of loan to equity will make my equity 400 in total, but authorized is only 150. No, sir. This leads to deemed conversion, increase of authorized share capital. So if this concept comes, I have to talk about 61, alteration of share capital. I have to talk about 62 subsection 4, this section, and I have to talk about 65, because whenever authorized capital is increasing, I have to intimate ROC. All those points will come. Of course, a company will not be happy when government converts loan or debt to share capital. So company can appeal to tribunal for namesake within 60 days if company is not satisfied. And this provision is not applicable to a Nidhi company. Very, very important. In previous case, SR is required. Here, SR is not required. Central government can pass the order anytime. Next, to bonus. Always when you start a procedure, guys, start with the approvals needed. For bonus, articles and board have to authorize along with ordinary. So articles, then board resolution, and then ordinary resolution. What is the source of bonus? I can use free reserves, SP and CRR. And for this, once you announce, it cannot be withdrawn. It cannot be withdrawn once it is announced. Next, important points. It should be made only for fully paid up shares bonus. Why fully paid up shares? We see in regular classes, but here fully paid up. So what if I have partly paid up? Then convert them to fully paid up shares. Any compliances to check? Yes, they should not be defaulting in interest on deposits or any debt securities or any statutory dues. So all the statutory dues on debt to interest should be repaid. And lastly, you cannot declare dividend and give bonus. So bonus should not be given in lieu of dividend, guys, instead of dividend. So with this we are done with rights and bonus also. Next two important points we have is buyback and shares with differential voting rights. Shares with differential voting rights, very, very, very important for our May 2025 exams. This is expected question marathon for May exams, right? So over here, very important. Again, what is the approval? Articles, order resolution should be there along with board resolution, but that is not given over here, but that will also come. And then Once this resolution will be passed through postal ballot. After the issue, maximum 74% can be in DVRs. Then I will classify next. Now coming to this DVR guys, I will classify into 3 years and 5 years condition. For 3 years, you have to see two important points. What are the two important points? No default in filing FS and annual return in the immediately preceding last 3 years, and also company should have not defaulted in the following acts: RBI, SCRA, FEMA and SEBI Act in last 3 years. In last 5 years, there should be no default. No default in all these guys. Look at this, all these. Basically your debt instruments and equity instruments, everything should be repaid along with interest and dividend if any, and IEPF transfer and PF gratuity, employee dues. So debt to equity, employee and IEPF. Next, to proceed further, some key points that we have. Explanatory statement should tell reason why we are doing this DVRs. Board report should give contents of explanation as to why we are doing this details, and company should also maintain register of DVRs. So this we call in class as 88, 102 and 134. Those who come to our class will know this becomes actually a rhyme in the class. 88 register of members, 102 explanatory statement, 134 is both report guys. Next, all other rights like bonus rights etc. are the same, and company cannot convert existing shares to DVR and DVR to existing shares. So let me repeat guys, I will split this into 4 parts. First is going to be my powers. Once that gets over 3 years and 5 years point, go through that. Next 88, 132, 102 and 134 explanatory statement, both report and this maintain DVRs register. And lastly 2 points will be all other rights are same, you cannot convert existing to DVR and DVR to existing guys. This is with respect to 43 rule 4. Next is sweat equity shares. Let me go to next set of sections over here. Okay, and deemed redemption. Let me go there. Yeah, sweat equity shares. Basically, it can be given. What kind of positions can come here? To whom I will give sweat equity shares? I can give to directors or employee at a discount for providing some know-how. Sir, should the director employee be director employee of our company? Not necessarily. They can be working in India or outside India. They can be director or employee of my holding company or subsidiary company. Same thing as well, subsidiary or holding company. Next, what resolution I should pass? I will pass a special resolution over here guys. Again, coming to approval, I told you, you will pass special resolution which is valid for 1 year. Sir, what is the limit over here? Limit is very simple. We have 3 limits. Maximum at any time, overall sweat equity cannot exceed 25% of paid up share capital. In startup means it's up to 50%, and each year, each financial year, maximum is 15% of paid up share in each financial year, or 5 crores, whichever is higher. So simple, maximum 25% sir. Startup na 50, in each year 15% of paid up share capital or 15%, whichever is higher. Next, other points again same. 88, 102 and 134 will come here also. What is 88 sir? I have to maintain register of sweat equity shares. 88. What is 102? I have to give justification along with my explanatory statement. And what is 134 sir? In both report I will give details. Beyond this, other points are what? Locked in for 3 years. I will lock in for 3 years. All other rights are same, and company should get it valued by a registered valuer and follow ESOP guidance note. So again, sweat equity I am classifying into 3. What is the approval? Special resolution. Repeat with me guys. Repeat with me. Valid for 1 year. Percentage 25, 50 and 15%. 25 overall, 50 overall for startup, 15% 1 year or 5 crores, whichever is higher. Next 3 points. 88, 102, 134. What is 88? Register of members. 102 explanatory statement. 134 is both report. Next, proceeding further, lock in for 3 years guys. Registered valuer should follow guidance note on AS, and all other rights like bonus etc. is same. This is section number 54. Now coming to 55, I am focusing only on redemption of preference shares. Especially in redemption of preference shares, I am mainly focused on deemed redemption. So what is this deemed redemption? You will go through other points of redemption guys. What is the sources? You can only use free reserves. You can't use securities premium. Face value will be transferred to CRR if it is done out of profits. If you use proceeds of fresh issue, no need to transfer to CRR. all that is fine. But when company is unable to redeem, I don't have money, we have a concept called deemed redemption, where I will pass entry old preference share capital account debit to new preference share capital. Sir, what is this, sir? Very simple. This basically says that I will issue shares for shares. For this you need to get 3/4 in value of consent from preference shareholders and approval of tribunal. If there are any dissenting shareholders, I will give them an exit opportunity. This is the concept of deemed redemption of preference shares, guys. Lastly, two more concepts I feel which is important expected for your exam is section 66, reduction of share capital and forced transfer. Reduction of share capital and forced transfer, guys. So what is forced transfer? Quickly I will finish. Forced transfer is basically if A shares are given to B and B to C and C to D. In this, who did the forgery, sir? The B person forced the sign of A and he bought for himself and he sold to C and D. What happens? A forced transfer is null and void. The person A will get the shares back. The shares will be cancelled in the name of the current shareholder D, and the person who did the forgery, we will find them and he will compensate the other suffering parties over here. This whole process company will take care. So simple, the transferee C or D is not entitled to be member. So after forced transfer, new member is no more a member. Original owner A continues to be the main shareholder, and then original owner can compel the company. So A can ask the company to give the shares back in his name and cancel the shares which are issued to the person after forgery. The innocent purchaser can recover the loss from the person who did the forgery. This is case of forced transfer, guys. Okay. Next we have a securities premium. This is very simple. SP, you all know what is SP. For what purpose I can use securities premium? Two B's we have, which is bonus, and it can be used for buyback. Buyback we are going to see next. So I can use it for bonus and buyback. And other than this, I can use for three writing off. Writing off what, sir? Writing off preliminary expense, or writing off commission or discount allowed, or writing off premium payable on redemption. Look at this. Bonus, buyback, then writing off preliminary expense on issue, writing off commission paid discount on issue, and writing off premium payment redemption of debentures or preference shares. So basically they are talking about premium or discount on issue. Look at this. Basically it is discount on issue or premium on redemption. This way you will never forget. So look at this, guys. Bonus, buyback. Then for writing off, what to say? For purpose of bonus or buyback, writing off preliminary expense and writing off discount on issue, premium on redemption on all the securities of the company. This is section number 52, which is securities premium concept. We are done with deemed redemption, we are done with sweat equity shares. Next, the buyback is very important for May 25. It has not come for quite some time. Buyback has a lot of limits, guys. One of the biggest procedures that we have itself is buyback. When I talk about buyback, it is section 68 plus along with section 66. So you have to read. I gave here also, see 66 reduction of share capital along with section 70 along with section 67. These four things you have to go through, guys. These four things: 68 buyback, 66 reduction, 70 prohibition, and 67. What is 67? Financial assistance should not be given, and debentures 70. Section 71. 71 is going to be my debentures. Okay. These four concepts I have given in our share capital and debentures chapter, guys. Very, very important. One of this is going to come in your exam. These 5 concepts I have beautifully explained in our Gen Z marathon itself. In our Gen Z marathon, go for the timestamp for share capital. I would have explained this for almost 15 minutes. Buyback, reduction, 70, 67 and 71. Because it's a long procedures, I am not discussing it over here. I want to keep this short. Go to the Gen Z marathon, which is anyway there in description. Watch that, guys. Timestamp is there. Ensure you get done with these concepts also. With this, I will be closing our share capital chapter. Expected question. This time expect minimum 10 marks in May 25. I am calling it for you guys first here itself. Let me move on to the next chapter now. Let's quickly revise charges chapter, guys. I'm going to now pick up pace because I want to finish this in 2 hours and I've realized we are a little bit behind the schedule, so I'm going to pick up pace for remaining chapters. Okay. Sir, in charges, what is section 81, 85? Both talks about maintaining register of charges. 81 talks about register to be maintained by ROC. 85 talks about register to be maintained by company. What is key point here? In company, when I'm maintaining register of charges, I have to maintain it permanently, guys, permanently. Instrument of charges for 8 years. But register will be maintained for permanent basis. What is section 80? Date of notice of charge. Here we talk about concept of doctrine of constructive notice. What is doctrine of constructive notice? Any third party dealing with the company should have, it is deemed that he has read and understood the charge document. He knows everything. It's a defense for company against third party. Here it can be a 5-mark case study question. Modification of charge. Let me go to section 79 quickly to show you modification of charge. In 79, these are the cases of modification. Change in interest rate or change in terms and conditions or increasing or decreasing the limits or partial release on charge or property of assets or change in repayment schedule of the loan. Repayment schedule, all these, and creating a pari passu charge. All these are modification. If there's a modification, you have to file to ROC again as per section 77. I will come to 77 timeline very soon. So what is important here? 2 exceptions. What is not a modification? What is not a modification is other than bank rate, where change in interest rate not just for me. Bank is changing for everybody. That one is not a change in what to say. It's not a modification. At the same time, they're also talking about this one. Yeah, they're also talking about one more exception. Working capital loans. Here it is, guys. Sorry, working capital loans. Whenever there's going to be a change in working capital loan, that is not going to be a modification. That's what I gave in section 79. Sir, what is the time limit in section 77? Simple. The time limit is very simple. First, you have to register the charge within the 30 days, guys. So register the charge within 30 days. Very important. Register the charge within 30 days of creation. If you fail to do that, you have another additional 30 days which has to be done with what fees, guys? Additional fees. And then if next 30 also you don't do, you will do next 60 days with ad valorem fees. So my time limit is 30, 30 and 60. Here additional fees, here prescribed fees, here it's going to be ad valorem fees. Are you following, guys? The same time limit is applicable even for modification under section 79. Under 79. Okay. Next, 82 and 83 talks about satisfaction of charge. What is 82 saying? Very simple. Where a party makes the payment, where the loan is repaid, where the charge is done, entire loan is repaid, you have to inform ROC. Inform ROC within how many days? Within 30 days. But they are giving you additionally overall 300 days including 30 days. That means additionally you have 270 days. Okay, you have to intimate ROC. Once you intimate ROC, what will happen? ROC will basically cross check with the other counterparty. So if the bank charge holder is telling the thing, they will cross check with the person taking the loan, or if the company is filing, then they will cross check with the charge holder, which is nothing but the bank. For cross checking, they will issue something called as a show cause notice, and for the show cause notice they will wait for 14 days. In 14 days, if there is no reply or no objection, ROC will proceed and register the charge. If there is any objection, then registrar will intimate the company, and based on objection they will proceed. What is 83, guys? 83, registrar to record satisfaction in case of absence by company. Basically, nobody informed ROC, then ROC by itself they will record the satisfaction of charge, and after recording satisfaction of charge, they will intimate the company within a period of 30 days, guys. Here no notice, I am only intimating the company within 30 days. So these are important for charge. Mandatory in May 25. Don't skip this the day. This is definitely going to come in your exam. Let's go to the next chapter now. Let's start off with quick expert question revision for deposits chapter, guys. In deposits, first we are seeing what is not a deposit. Very, very important. This time we can expect at least 6 marks from this if it comes. What is not a deposit is the first part in our book. There are about 15 points over here which you have to go through. They will ask you 2-mark questions, 3 into 2 marks, or 1 2-mark question, or an MCQ. Is this a deposit or not a deposit? Few important points over here. First set of points is all kinds of borrowings from bank, local authority or any kind of loan facility, international banks, intercorporate deposits, intercorporate loan, all these are not deposits. Second, when you make share issue and if you don't refund the money in case of private placement within 75 days and in case of normal issue within 45 days, after that grace period it becomes a deposit, guys. Next they are saying any kind of liability like debentures or bond or any non-convertible listed debentures, all these are not deposits. Fairly simple. Next important points I'm highlighting here. From directors and relatives of directors of private company is not a deposit, guys. Next, very important point over here, which is worthy of 2 marks I'm discussing. Security deposit received from employee without interest. If interest comes, it becomes a deposit and it should not exceed his annual salary. Annual salary should not be exceeded, guys. Amount held in trust. Sir, what is this, sir? Amount held in trust. What do you mean by this? Basically, I give money to somebody to keep it on behalf of me, keep it as trust. Then it's not counted. Like I give it to my friend, give it back to me after 1 month. These things are not deposit. Next, point 7 is very important. Promoter's loan. Promoter is giving loan to the company because the lending institution has given a stipulation, has given a condition that I have to give a loan. So promoter's loan as a stipulation for lending will not be taken as what, guys? Deposit. Next, over here, any trade advance you should set off within 365 days, then not deposit. Any advance for immovable property you should set off as per the terms of the contract. For both 9 and 10 there is a note below. For such contracts, if the amount becomes repayable for reasons company is not licensed to provide this, for example company lost license for construction, then money should be due, it should be paid within 15 days from the day in which it is due. If it is not paid within 15 days, then also it becomes a deposit, guys. Then any kind of security deposit for supply of goods and service, that is also not a deposit. Then sectoral regulator like advance tax, TDS, all these are not deposits. And lastly, electronic media, subscription for Mint or Netflix, all these kind of things are not deposit. Sir, I am paying AMC, sir, for warranty or maintenance. You can pay, not a deposit, but maximum 5 years or under general trade practice, whichever is lower. Most important over here is this point, amount collected by all these people like mutual fund, collective investment of scheme or real estate infrastructure trust. Then any money received by chit fund or Nidhi company is not a deposit, guys. Again, startup company, if they receive 25 lakhs from a single person, same person is giving 25 lakhs in a single tranche, then this is not a deposit. Let's say I am a startup company X Limited, I am receiving 3 crores, but I am receiving 10 lakhs every day for the next 30 days, then this becomes a deposit because you are getting, what to say, less than 25 lakhs, you are getting 10 lakhs in 30 different days. But instead if you get all the 3 crores in one complete transaction, it will not be a deposit. This money can be for equity shares or repayable within 10 years from the date of issue. Therefore, more than 25 lakhs from a single person in a single tranche is not a deposit. Are you following, guys? Okay. Let me proceed. Next set of things in deposit, if you see, circular. What is the circular concept? Again, is very important, guys. What is the circular? If you go to the end of the chapter in our book, if any company wants to issue a deposit, then they have to issue a circular. If it is for members, they will issue circular to members. If it is public, they will give circular to the public, guys. Now, if they are giving to public, I have to ensure circular comprises of all these 5 points. What are the 5 points? It should first have details. In the website it should be placed, and you should also be publishing it in the newspaper, guys. Then they are also saying if you are giving to members, you send it in speed post or electronic mode, and circular should be given at least 30 days before it should be given. Next, company has to give circular to members with some details like financial position of the company, credit rating and details of deposit. What I have just done, I have just read what is there. Newspaper, website, and then you should also give it to existing members with these details. So this is important. No. What is more important is the validity of this circular. What is the validity of circular? It's valid for 6 months from closure of issue or date of AGM where FS is held, or if there is no AGM, on last day when the AGM should have been held. Basically they are trying to say from end of financial year within 6 months it is valid. Before that, if AGM is held, then that day. If AGM is not held, what is the last date on the AGM should be held? Within 6 months. So validity is for this period, guys. Basically 6 months from end of financial year. And this chapter is not applicable for a banking, NBFC and housing finance company. This is for circular for deposit. Lastly, issuing deposits. All small concepts you focus over here, guys. In the procedures, don't have to mug up the procedures. Small concepts. Sir, what are small concepts? Let me highlight a few over here. For a private company, maximum is 100%. 100% of what? 100% of paid up share capital plus free reserves plus securities premium. Private company cannot get from public. If it's a public company, non-eligible, from members 35%. Eligible company from public is 25. Therefore, for members it's going to be 10%. Overall has to be 35, guys, but there's a sublimit. From public it has to be only 25%. Therefore, for members it's going to be 10%. This can be in any ratio in such a way public should not cross 25 for eligible public company. For government company, 35% in any ratio. So this percentage of what, sir? It's a percentage of paid up share capital plus free reserves plus securities premium. Now, sir, what is the duration of deposit? Can be a separate question. 6 months to 36 months. Sir, can I go for short term deposit, sir? Yes, sir. 3 months to 6 months. Minimum 3, maximum 6 months. That should be maximum 10% of paid up share capital plus free reserves plus securities premium, guys. Like this, any concept can come. So I want to issue for more than 100%. Possible if you follow these points. Startup company can go for more than 100%, no limit over there. And for other private companies, if these limits are met, I am a standalone company, sir. I am not associate, subsidiary or holding of any other company. At the same time, I am not defaulted in any borrowings that I have in the company, not defaulted in any borrowings, and not defaulted in filing annual return and financial statements. When it comes to borrowing, important point over here, the borrowings of the company should not exceed 2 times paid up share capital or 50 crores, whichever is lower. For example, sir, my company's borrowings is 70 crores, sir. Okay, now my paid up share capital is 30 crores. What I will do, 2 times paid up share capital, 2 times 30 is 60. I will compare 60 or 50 crores, whichever is lower. Which is lower? Of course 50. My borrowings is 70 crores. That means it's more than 50. That means I will definitely cannot go for more than 100%. In simple words, guys, if your borrowing is going to be more than 100, it's going to be more than 100, more than 50. If my borrowing is going to be more than 50, then definitely you can't make deposits. If it's less than 50 only, you have to check the 2 times condition. Okay. These are some important points. What is eligible company? Of course, it's a public company and net worth should be 100 crores or more or turnover 500 crores or more. Here it's an OR condition and not an AND condition. Okay. Next is some other points that you have to go through from procedure. Any point can be case study question. Let me highlight the important points over here. First, from members, you should not have defaulted deposits earlier. Then you should provide security by creating a charge. Important point over here, from members means I will create charge on assets, but if it's from public, I have to create charge only on tangible assets, guys. Only on tangible assets I would have mentioned over here. Yeah, only on tangible assets I can create charge. If it's from public, some additional points are there, like you should get credit rating on a yearly basis, and it should also be and the charge you should be valued by a registered valuer. Come down, other points, I have explained this in other marathons, guys. I'm quickly running through these points over here. You need to go through all these points, like premature of deposits and the 1% point you have to go through. Okay, if you premature, 1% will be reduced, but in case of war risk, 1% will not be reduced. Then what is 7 days? Entry should from the date of deposit. Within 7 days you enter in register of deposit. Within 21 days I will be giving a deposit receipt. Deposit receipt over here, guys. Sir, how many deposit holders I can have? Maximum 3 members can be there. More than 3 joint deposit not possible. Sir, I never repaid deposit on time. Interest, don't worry, 18%. Then return should be filed within 30th June of every financial year. So in these procedures, quickly go through all the points of deposits. Guys, with this we are done with deposits. Let's proceed to next chapter. Let's move on now to dividend chapter, guys. One of our favorite chapters because easy chapter, one question mandatory, 5 marks will come in exam. Small and important chapter. Read this chapter fully, guys. Even though I'm doing expert question, it almost covers the entire chapter. First is interim dividend concept. If you go to this dividend chapter, now interim dividend, what they are saying, when it comes to interim dividend, it's a dividend that's been declared and paid between 2 AGMs. So basically dividend declared other than AGM we will call as interim dividend, and sometimes in AGM itself they will declare interim dividend also. It's declared by board of directors. For this profits also I will use current year or previous quarter profits. Here the most important thing before I come to that, look at this. Interim dividend can it be revoked, sir? Yes, by passing unanimous resolution. If all the shareholders consent, we can revoke interim dividend. Here let me take the most important concept where students make mistakes in interim dividend. When you are declaring interim dividend for any particular quarter, guys, for example, let's say I'm declaring for Q3 of a financial year, I have to cumulatively check Q1 plus Q2, cumulatively if it's profit or if it's loss. Cumulatively if it's a profit, I can proceed and declare any amount of interim dividend. There is no limit. I can use current year profits and previous year profits. That means in current quarter preceding the quarter in which I am declaring dividend. So I am declaring in Q3 up to Q2 end. If it is profit, you can declare any amount of dividend including reserves. If it is loss not for Q3, Q1 plus Q2 cumulative, if it comes as loss, guys, that's when they go to rules. There is only one rule. That time they are saying if you want to use previous year profit, because this cumulatively it's loss, that means current year loss, that means I'm going to use previous year profits. Then they are saying the rate of dividend shall be average rate of last 3 years. That's it. Average rate of last 3 years. It cannot exceed beyond this. That's about it, guys. Okay, this is for interim dividend concept. Next is going to be 126 abeyance. Very sorry about this. Yeah. Okay. Abeyance. What is abeyance saying? Sometimes when there is share transfer is pending because of some dispute or any problem in transfer deed, all the benefits that come out of that share during the transfer of pending stage, like dividend or rights or bonus, all these will be kept in abeyance. Abeyance means it will be kept in hold. So rights and bonus will be kept in abeyance and dividend will be transferred to unpaid dividend account as per previous section. Next, penalty for non-compliance. If dividend is not paid, if company fails to pay dividend within 30 days, remember guys, there are two things: dividend not claimed, dividend not paid. So where dividend is not paid within 30 days, company's fault, what is liability? Interest is going to be 18% per annum, and every director who is involved in this will be liable up to 2 years imprisonment, and officer and director up to 1,000 rupees per day of delay, guys. Then there are some exceptions where this penalty is not applicable. Sir, what are those exceptions? We already know. Operation of law. COVID came, so I can't pay dividend. Shareholder has given directions and those directions cannot be complied, and the same has been communicated to him. So this point they have tested so many times. Shareholder giving directions, company could not follow them, the company communicated back to shareholder, then company is not liable. But company fails to communicate, then company is liable. Where there is dispute to right to receive dividend, Ambani brothers both are fighting who has to get dividend, there is dispute. Basically 126 point is an exception over here. And dividend is lawfully adjusted. I have to pay shareholder dividend, he has to pay me call money, both I will adjust, lawfully adjusted, or any other reason where failure to pay is not the fault of the company, guys. This is section number 127. Next to 124, timelines in section 124. Of course, we have all this in our GENZ, guys. Okay, but I'm just doing it over here just for our quick revision. First, once dividend is declared, it has to be transferred to separate bank account within 5 days. Everything is there in this section, and it has to be paid within overall 30 days. I'm sure you all know this. If it's not paid or unpaid or unclaimed, even shareholders' fault, then within the next 7 days, I will be transferring this to a balance call, account called unpaid dividend account. Money will remain in this unpaid dividend account from the time it came for a period of 7 years. How many years, guys? 7 years money will remain over here. Now, if you don't transfer here within 7 days, if you don't transfer, for delay in transfer to unpaid dividend account, interest is going to be 12%. Once you transfer to unpaid dividend account, within the next 90 days, you have to prepare a summary report, a statement containing last known address, amount of unpaid dividend, and publish on the website of the company and website which is authorized by central government for this purpose case. So time limit 5 days, separate bank account. 30 days, make payment. If not, within next 7 days, unpaid dividend account. Not transfer in 7 days, interest how much? 12%. Money will be in this account for how many years, guys? 7 years. After 7 years, where it goes? Section 125 IEPF, tested in latest attempt. And within 90 days of money coming into unpaid dividend account, I'll prepare a statement with all the last known address, etc. This is section 124 unpaid dividend account. Next, the last one, inadequate profits and 3 rules for dividend. Because I am recording this after accounts exam. Basically, accounts exam is over. In your accounts exam, I saw the 3 rules which came for dividend. Therefore, for law, it becomes a little less important because they tested in accounts itself. But still, let me quickly revise because it's there in our expected question. Source for declaring dividend is always going to be current year, previous year profits, or combination of both, or money guaranteed by central and state government. Whenever you are going to use previous year profits, that means current year you don't have adequate profit. Does not mean loss. My profit this year may be less, inadequate profit. That time you will go for rule 3, where there are 3 rules given: rate rule, usage rule, and balance rule. This only came in accounts system. I hope you got those 5 marks, case. If not, get those 5 marks in law if it comes. Rate rule: average rate of dividend, just like interim dividend, cannot exceed average of last 3 years. Usage rule: the amount you can withdraw shall not exceed 10% of paid up share capital and free reserves. Amount to withdraw shall not exceed 10% of paid up share capital and free reserves as per latest FS case. Once you withdraw this, first amount so utilized should be first adjusted with the losses of the current year, if any. Last one, balance. After withdrawing, the balance in reserves should be at least 15% of paid up share capital. Let me repeat, the balance in free reserves should be at least 15% of paid up share capital. 3 important rules. Again, dividend should be given only in cash case. Cash means not cash. It should be given in banking modes like check or any bank warrants. With this, we are done with quick revision of expected questions of dividend chapter, not the whole dividend chapter. I am repeating this again and again. Let me move on to the next chapter now. Let's quickly go to accounts of companies, revision of expected questions. Concept related to consolidated FS in section 129, exceptions when consolidation is not needed, and periodical FS. Let me go to our material and then I will explain over there. In section 129, when you go to consolidation, guys, first, when consolidation is not mandatory, consolidation exception, we have 3 exceptions. 1, unlisted company, sir, no need consolidation. Ultimate or intermediate holding company is doing consolidation, so I don't have to do consolidation, meaning H, S1 and S2, sir. My ultimate holding H is doing consolidation, therefore subsidiary 1 need not do consolidation of subsidiary 2. Next exception, members of the wholly owned subsidiary or partly owned subsidiary who are entitled to vote have been intimated in writing. I am informing my members of subsidiary that we are not going to do consolidation. They are also not objecting and it's fine. They are saying it's okay. Therefore, we can proceed with consolidation in that case. No, we can proceed without doing consolidation in that case. Exception for consolidation. Next, other concepts of consolidation. Who should do consolidation? Consolidation is important for all companies with subsidiary. Okay. Next, if this holding is a foreign company, then S1 should do consolidation. Guys, then S1 should do consolidation. Next, in case of companies, they have to prepare salient features of subsidiary in a form called AOC1. Next, when it comes to foreign companies, foreign company and consolidation very important. Foreign company and Indian company will have holding subsidiary, different financial year. How to do consolidation? Try to convert to the same financial year and do consolidation. If that's not possible, get permission of central government. Central government will give exemption, then no need to do consolidation, but it is not applicable for a specified IFSC or private company. Next, foreign companies in different dollars or different currency, convert to India. Different language, convert to India. Sir, in foreign country, audit is not mandatory. I have only unaudited FS, sir. Then take the unaudited FS and do consolidation. So not audited of foreign subsidiary, take it as it is. Dollars, convert to rupees. Then in different language, convert to English. Different financial year, try to convert to same financial year. If not, get permission of central government, same will be exempt. 129A recently tested, guys. We have something called for unlisted companies, periodical review and concept is there. Periodical review for unlisted companies. For this unlisted companies, limited review audit shall be conducted. What is the period to do it? ROC has not yet given time limit for that. Therefore, whenever you do this limited review audit, you have to file to ROC within 30 days. This is the first point, guys. Second, CSR, I always say it's important, but this time I'm putting it over here because it came in Jan. I'm still saying may repeat, but chances are less. So let me finish all other concepts and then I'll come back to CSR. Signing of FS and director's responsibility statement, pretty much important, guys. Let me go to 134. Who will sign FS? FS will be signed by whom, guys? Chairperson of the company. If chairperson is not there, for example, Sun TV Kanadi Maran is chairperson, he is not there, busy watching IPL match. Anyway, SR is losing, but he is watching CSK match, at least enjoying that match of beating CSK. If he is not there, then two directors, one shall be managing director. Therefore, it's going to be chairperson or two directors and one shall be managing director. Plus. Additionally, company will have CEO, CFO and CS if they are appointed. So CEO, CFO and CS if they are appointed should also be there. Next, director's responsibility statement. If this comes in examiner, it will be a straightforward 4 or 5 mark question. Straight away you have to mug up those questions, guys. Here, remember the keywords, I highlight the keywords over here. What is it? You can't write this in your own words. This is one such question why I have to write as it is. First, company is following accounting standards. If there is any deviation, reason for material departures. Company is also following accounting policies which is followed consistently. If there is deviation, reason. So accounting standards, accounting policy. Third, proper and sufficient care is taken for adequate accounting records and safeguarding of assets. So sufficient care for adequate accounting records and safeguarding of assets, and there is a system for preventing and detecting fraud. Whatever is in bold here, you have to write as it is, guys, if you want the full 5 marks over here. FS is prepared on a going concern basis. Then proper system is there for compliance for applicable laws and regulation. And if it's a listed company, they have laid down internal controls, internal financial controls. This point, don't expect case study, guys. If it comes straight away, all the 6 points you have to write if you want to get full marks over here. This is my signing of FSN. Director's responsibility statement. Internal audit and XBRL filing, guys. Let's go. Let me ask you questions in internal audit. Who has to do internal audit? Any company which is following this limit. We'll come to that. Now, which professional? It can be any professional. CA, cost accountant, chartered accountant, or it can be company secretary, or it can be any other professional. Who will appoint? Management will appoint, guys. Appointed by the board of director. Therefore, he will report back to the board of director. Internal auditor, unlike company, need not be a firm. It can be individual, partnership firm, or a body corporate. It may be a CA in practice or not in practice. It can be somebody as an employee of the company or even on third party basis. For whom it's applicable, sir? For example, you go for PVR movie on weekday without ticket, you will show some random QR and enter. How do you control all these things? Applicable for listed company. For listed companies, almost all limits are applicable, guys. Next, unlisted public and then private company. The limits are basically 200, 100, 50 and 25, all in crores. Come on, you passed this exam now, you can earn in crores, guys. So turnover of 200 crores or more, loans and borrowings of 100 crores or more, paid up share capital of 50 crores or more, deposits 25 crores or more. All this previous financial year, no sir. Turnover and 250, turnover and paid up share capital, I will check for previous financial year. 125, borrowings and deposits, I will check at any point in previous financial year. When it comes to private company, all the 4 are not applicable. Just to the 200 and 100 point, which is my turnover and borrowings point alone is applicable for applicability. This is section 138. Let me go for XBRL. Sir, XBRL is what? Generally in section 137 they talk about copy of financial statements. Copy of what, guys? They talk about copy of financial statements to be filed with ROC within 30 days from conclusion of AGM if AGM is held. AGM not held now, within 30 days from the day when AGM should have been held. Sir, AGM held and FS not adopted, still within 30 days of AGM you file unadopted FS and later you will file the final FS. Over here I am discussing mainly about XBRL reporting, very important. For certain companies, they have to file this to ROC in a format called XBRL, which is called Extensible Business Reporting Language. Not applicable for whom? Not applicable for NBFC, housing, banking, insurance company. Here the catch. Once you follow XBRL, you have to follow for life. That means I don't have to check this limit every year. Once applicable, okay. Sir, limit not applicable, sir. Simply I went and followed. Then still you have to go and follow for rest of the life. For whom? Listed company, obvious. Then everything else is or listed company or any company having paid up share capital of 5 crores or more. Any other company having turnover of 100 crores or more. So paid up share capital 5 crores, turnover 100 crores, or not following all the above, sir, but I am following Ind AS, then you have to file an XBRL. Next, section 30 and 131, reopening of accounts and voluntary revision. Let me go to both these sections. Section 130 talks about tribunal order to reopen. 131 talks about our option to go to tribunal for voluntary revision of FSN, both report. Let me do a comparative study of both of this. First, section 130. Anybody, it can be central government, SEBI, income tax, statutory, or any person, article, you, me, anybody, if I have a doubt about a company, if they are doing accounts in fraudulent manner or company is being mismanaged, casting doubt on reliability, we can apply to the tribunal. If tribunal feels that it's fraudulent manner or there's mismanagement, they will pass an order for reopening the accounts for the last 8 years, for the 8 years. However, for that company, if already some investigation is pending and going on, then we can order for a longer period if already investigation is going on. What is 131? Others don't have to complain about me. I myself realize that something is wrong in my company's books of accounts and FS. Then what I will do in financial statements or both report. Basically 129 or 134 I found something is going wrong. Then what I will do, I will first, let me prepare a timeline. First I will pass a board resolution and then file to, what to say, ROC, tribunal within 14 days I will go to tribunal and form NCLT 1. Tribunal will take its own time and then they will cross check with 3 people. Who are the 3 people? Income tax authority, central government and original auditor. Okay, I am again repeating, guys. If you want to revise the FS or both report, you have to pass a board resolution. You have to pass a board resolution and file to tribunal within 14 days in NCLT 1 after the board resolution. Tribunal will cross check with central government, income tax department and original auditor. Who was the original auditor who signed that? Taking into above consideration, they will take their own time and pass the order. Once they pass the order, you have to intimate. So they will pass the order, no time limit for order. Once they pass the order, I will intimate ROC within 30 days. Within 30 days, I will be intimating the ROC, guys. So simple. Pass board resolution, go to tribunal within 14 days. They will cross check with 3 departments and then come back to us, pass the order. We will intimate ROC within 30 days after getting the order, guys. Sir, how many years I can do revision, sir? Here we can do for up to 8 years reopening. Here you can revise only for maximum 3 financial years. Only 3 financial years you can do. And for each financial year, you can do it only once. For each financial year, you can do it only once, guys. This is voluntary revision of FSN. Both reports, section 130 and 131. Next is circulation of FS for listed company, other companies in section 131 along with notice. So there is heavy chance that 136 concept can be tested along with notice, guys. So 136 is basically before the AGM. If AGM is over here, before the AGM, 21 days before the AGM, just like the notice, you have to circulate financial statement to members. Over here it should be given 21 days before the AGM. Simple. Along with this, you will also be giving notice under section 101. Sir, shorter notice possible? Yes, just like notice. If 95% of members entitled to vote give consent, I can give a shorter notice. What is important over here is this point. For these companies, they have to send the notice in electronic mode only. Look at this. All listed companies and public companies with net worth of 1 crore and turnover of 10 crores. So basically what they are saying over here, what they are saying, guys, net worth of 1 crore and not or turnover of 10 crores above. If it's both are satisfied, then they may circulate in e-mode, but here the may will be read as shall. They should be circulated in electronic mode. So listed companies, other companies, net worth is 1 crore or more or what to say, turnover 10 crores or more will circulate in electronic mode. Important area. With this, we are done with accounts of companies. Sir, what about CSR, sir? Yes, CSR is important, but CSR itself will take another 10-15 minutes. I have revised the CSR, pakkali, the entire CSR, because entire CSR is bigger than whole accounts of company chapter. Just to save time of this, CSR alone, I'm sure you all know by now, we have our Gen Z marathon. In that, go to books of accounts, find CSR. I have given the timestamp. I will revise it in just 10 minutes, guys. Entire CSR. I'm again repeating and telling you guys, if you are watching this, if you can make time somehow, go watch the Gen Z marathon. At least for a few chapters, you will know how impactful it is. With this, I'm done with accounts of companies, and then we will now move on to last two chapters, auditors and foreign company. Now starting off with auditors, first is section 142 and 145. 142 talks about remuneration of auditor. In remuneration of auditor, it's fixed in general meeting. Who fixes the remuneration of auditor, guys? It is fixed in the general meeting by the members. Members will fix it. So therefore, you have to pass an ordinary resolution. You have to pass an ordinary resolution. First audit is decided by the board of directors. This can be MCQ question. First audit remuneration, board of directors. Subsequent shareholders, ordinary resolution in the general meeting, we will fix the remuneration. Remuneration shall include travel expense or does not include travel expense, sir. Very simple. Reimbursements sometimes are inclusive, sometimes can be extra. But remuneration does not include fees for other service like tax audit and etc. Okay. Next to 145. Auditor to sign FS. Who can sign? Only auditor has to sign. Can I give article? No. Article all cannot sign. And the auditor also has right in the AGM to read out the comments in front of the AGM, in front of all the members, all the important observations and disqualifications. 142 and 145. So 145 is signing. 146 also I will add. Actually, I wanted to cover 146 only. Auditor to attend AGM. Attend AGM, very important, guys. Attending AGM. Will auditor get notice of general meeting? Yes. Can he attend the auditor? He has to attend. This is the main question. He has to attend. But if I have multiple agents at the same time, I will send some authorized representative, and such authorized representative should also be a chartered accountant, guys. Okay. Next, penalty provisions 147 amendment. As a CA, after qualifying with all the hard work, if your corrupt buddhi comes into you, sir, I will start making more money, sir. I am a dishonest person. For me, money only is more important. Ethics are not important in life. Like this, I know so many people. Go slap them tightly and put them in this punishment for any contravention, especially 139, which is appointment of auditor. 144, not to render certain services you are not supposed to render, you still rendered. Or 145, auditor is supposed to attend and sign. If he is not doing both of these, then general penalty is given. With intention to default intentionally, then you have 8 times the remuneration of whichever. Just run through this penalty, guys, which is very, very important. Additional liability. If you are convicted, sir, only penalty, no, sir. Maximum 25 lakhs to 8 times, whichever is lower, no, sir. Not just this, guys. Apart from this, what they are saying, all the loss for all the concerned parties, you have to reimburse from your personal money. You have to reimburse and refund the remuneration. For if it's fraud, you are personally unlimited liability. And criminal liability, you will be arrested. But other partners will not be arrested, but they are liable for all the losses. So keep this penalty in mind, guys. Very hardly few penalties you read. So this penalty is also fairly important. Run through this. Next, to fix that, guys. Now coming to auditors chapter, guys. The remaining questions apart from what you have already seen. 141 qualification and disqualification. 139 appointment, mainly related to a government company, because other company they have already tested. And let me add on over here, 143 powers and duties, very important for this attempt. And 144 auditor non-audit services, the services which auditor should not perform, what he should not be performing. And 140, this time I am marking this chapter as a little bit important. That's why if you see expected question, almost the entire chapter is covered over here in auditors chapter. So these remaining sections 139 and 140, 141 and 143. Okay, so 139 which talks about qualification, disqualification, 139 which talks about appointment, and 143 which talks about powers and duties, 140 which talks about removal, and lastly even 144. These 5 sections, better to do them in detail, guys, because anyone can come. We cannot predict that well here like other chapters over here. So for this, just to save time, because when am I recording this, guys, look at this, I am recording this immediately after accounts exam at 9 p.m. at 9:40 now. Maybe in 1 hour once I merge you will get the video. So for these 5 sections I will again send you to the Gen Z marathon. Go watch the Gen Z marathon. It's an amazing piece of lecture where in 20 minutes all these sections are fully covered. Since these are fully important, go read that. But again give more important to government company concepts of appointment, casual vacancy in auditors. Very, very important. Let me move to the last act in Companies Act. I know of course we have meetings left, but before that let me go to last one over here, which is foreign company. Or let me do one thing. Let me just, let me finish foreign company. Section 379, what is a deemed Indian company? Okay, what is deemed Indian company? In foreign company chapter, 3 types of companies, guys. One, a company which follows full Companies Act. Second, a foreign company which follows only this this chapter. Basically a foreign company which is having incorporated outside India, place of businesses in India by itself or through electronic mode. But here I am not discussing all of that. I am discussing about a case where it is deemed Indian company. It is 379. Here I am talking about a case where not less than 50% of the paid up share capital, both equity and preference. Let me repeat, guys, not less than 50% of equity and preference is held, even though the company is incorporated outside India, but if it's held by one or more citizens in India or one or more companies in India or combination of above. So basically one or more citizens in India, one or more body corporates incorporated in India. So basically Indian people or an Indian company is holding more than 50% of paid up share capital. It is deemed as if it's a company incorporated in India and they have to follow full provisions. In this very important, we have sums also over here. They will give you sums over here, equity and preference number kuduthruvom. You have to compute if 50% is coming. Be very careful here to include both equity and preference. Paid up share capital only, paid up. Remove all the calls. Okay. Next, name board of foreign company or provision of prospectus in MCQ area. Here what they are saying, very simple, guys. In section 382 they are saying, whichever place where they have place of business in India, company should have a name board in India and the prospectus should also have what name, which country it's coming from. So if it's a German company now, German company name should be there, which country it's coming from. Circular clarification, what is meant by electronic mode, very, very, very important. Basically this chapter is applicable if I am a foreign company incorporated outside India and I have a place of business in India by itself, not physical or through an agent, physically or electronic mode. Sir, what is this electronic mode, sir? The electronic mode only covers this entire dabba. Basically electronic mode, they're saying any kind of digital supply transactions, any B2B, B2C, data interchange transaction, or any deposits accepted, any web-based marketing, financial settlement, or any database services, telemarketing, your Facebook ads, telecommuting, telemedicine, online therapy, then information research, education, online courses that you take, AI courses, anything that happens online, all communication through email, mobile device, social media, all this will come under electronic mode, guys. So run through these points to know what is included, what is not included. I have highlighted the keywords over here. 381 and 384, filing of accounts and annual return for a company. Anyway, I would have been uploading one more separate video because it's very confusing how to file FS. Look at this, filing of FS and annual return. We have 4 cases, guys. Somebody will get scared looking at this. One we have for a private company, then you have for LLP, and then you have for a foreign company. 3 different cases. Now we are discussing for foreign company. That's why I will be uploading tomorrow or already by the time you are watching this must be there, a separate video on how to file FS and annual return in all the different cases. But here let me quickly add it over here. So filing of annual return and FS. Annual return a company should file within 60 days from the end of the financial year. Foreign company file within 60 days from end of financial year. Sir, what about books of accounts? Books of accounts will be filed, FS will be filed within 6 months from end of financial year. This is just like LLP. In LLP also annual return within 60 days from end of financial year and declaration of solvency 6 months from end of financial year. So same as LLP, but here attachment, very important. I am expecting this to come in exam this time, guys. 3 important attachments we have to give. Statement of related party transactions, repatriation of profit and transfer of funds. So foreign company, related party transactions in India, then repatriation of funds, how much funds they are taking back outside India, and statement of transfer of funds should also be disclosed. This is 381. RTP May 25 amendment is there. What is the amendment, guys? The amendment says you have to file FC1 within 30 days. The time a foreign company comes to India, you have to file FC1 to ROC within 30 days, and it should be given to jurisdiction of New Delhi, but nothing but Noida, approval of authorized representative. If it's given exempted, if the RBI says no such approval is needed, then no need to give such approval. Okay, next 392 and 393, last two sections in foreign company. Let me complete that, guys. Okay, 392, always if you see there's any default pins, there will be penalty for just what? 50,000 rupees per day, 50k per day. No, normally it will be 500,000 per day. Here it is 50k per day. Lastly, section 393, again an important thing which I feel this time this can also come in exam. If a foreign company comes to India and does not register in form FC1 within 30 days, foreign company cannot sue third party can sue foreign company. We saw this in Partnership Act, same thing. Foreign company cannot sue third party can sue foreign company, meaning all the contracts entered by foreign company is valid with respect to third parties, but third party is not valid with the company. So it will not affect the validity of contract when sued by third party. However, company cannot counterclaim or counter sue. When foreign company fails to comply, look at this, it will not affect the right of third parties. However, it affects the right of company to sue third parties. Are you following, guys? With this we are done with expected question of foreign company. I will still recommend again over here, guys, same foreign company in Gen Z. I will be spending only 10 minutes. Go watch that, because full chapter I would have covered over here, like points like expert, prospectus. Here I am doing only expected question. Okay, last one thing is left in Companies Act. With that, Companies Act will be done. We can go to other laws, which is other laws. Let's start. So management, let me start off. Last chapter that we have is management administration. In Jan 25 they ask for more marks, so I believe in May 25 they will drop the weightage, but they will still ask. For want of time for me to upload the whole thing quickly, I will brush up the concepts what's important over here, but I will strongly recommend management administration is a 25-minute revision of full chapter in Gen Z, guys. Go watch the Gen Z over there. Important concepts over here for you to ensure to cover them. What are they, sir? Very simple. First one, if I see management administration, ensure to learn about 8990 not tested anytime, beneficial owner and significant beneficial owner. Once you, who is it? Basically I am registered owner, but I am giving dividend to any binami over there. Don't write binami in exam. Beneficial owner, so I have to intimate ROC in 30 days. Beneficial owner will intimate ROC within 30 days. ROC will intimate, I will intimate company in 30 days. Beneficial will intimate company in 30 days, and company to ROC within 30 days, guys. Who is SBO? Somebody who has 10% or more of the voting power or paid up share capital or control or significant influence. These points are covered in Gen Z notes. Go watch that. Very, very important. Annual return, important, not tested for a long time, and report on AGM. For listed companies, from end of AGM, within 30 days, they have to file a report of AGM to ROC. EGM related provisions important, section 100, guys. 3 months you should keep EGM. Who will requisite? EGM cannot be adjourned in case members itself called and members didn't come. All these provisions go through. Section 111, circulation of members resolution, time limit. That one you go through, guys. 101, notice and proxy, long due. Most likely we can see this only in your paper. So run through this. All these are covered in our Gen Z, guys. So this topic alone, pardon me, I want to put it out very soon. Not that I am tired, but by the time I finish recording another 20 minutes and merge, it will become late for you. You have only 1.5 day time. So that's why whichever topics Gen Z is already pakkawa done, I am linking you to Gen Z over there, guys. Okay. Then minutes, very, very important. 118, 119, read them, guys. In voting, electronic voting came in Jan. So this time postal ballot is important. Go through postal ballot. Concept of chairman, MTP May 25 question is very important. Concept along with special order resolution for vote count and validation. Run through that, guys. And AGM related concepts, section 96. So almost half the chapter I have put here, another half is not there. Run through this using the Gen Z marathon or the full marathon. With this, pakkawa done with Companies Act, guys. We will move on to other laws marathon revision. Thank you. For interpretation of statutes, what I'm going to do, because I'm just going to quickly summarize this in 5 to 7 minutes, tell you what each concept stands for. You need to pick the keywords from the material. From the material only you have to take the keywords, guys, because this is one such topic where if keywords is not there, you are not going to get your full marks. Sir, what is doctrine of contemporary exposito? This is part of our secondary rule in iOS. What this says basically is, when you are trying to read a law, try to understand from the time when it was passed. So if a law is made in 1940s, you can better understand if you look at it from 1940s. That is secondary rule of interpretation, doctrine of contemporary exposito. Keyword here is, this law should be understood at the time when it was passed. Okay. Next, elements of document and interpretation of deeds and document. Very important for our May 2025 exams. Over here, if you see, interpretation of deeds and documents, it has 3 sub rules under that. We have a golden rule, we have elementary rule, and we have conflict resolution. What is golden rule saying? First of all, what is interpretation of deed and document? Deed and document is nothing but a document that is made between 2 parties, like a rental agreement or a movie ticket, all of that. In that golden rule, they are saying, read the document as a whole and give importance to circumstance where the word is used, and also give importance to the training and expertise of the person who are drafting these documents. Elementary rule says, when a word is used in a document, no, meaning is going to be same. The meaning of the word is going to be same across the document. Same word cannot have different meaning unless the context compels a different meaning. If there is going to be conflict between 2 or more clauses within a document, they are saying the earlier clause will override the later clause. What will override later, guys? Earlier will override the later clause, guys. But same thing when it comes to external aid. So look at this. In interpretation of deeds and documents, earlier. So look at this. In deeds, earlier will override whatever comes later. But in interpretation of act, interpretation of law, between two acts, later, if there is a conflict, then later, look at this, in act, in case of act, later act will override the earlier act. Are you able to follow, guys? Next is, sir, what do you mean by this one? Elements of a document, and here one more thing, be very clear with the terms, guys. Sometimes if they use the word, because we don't know Latin terms that well, correct? So if they use the word like this, absoluta means absolute, literal construction. Wherever you see Maggie, reasonable construction. Maggie vanda reasonable construction. Wherever you see this Genelia actress, Genelia means harmonious construction. She's acted in all movies, Tamil, Telugu, Hindi. So Genelia, harmonious construction. Then if you see this word constitute, C-O-N, contemporino exposito. Okay, elements of document is nothing but what we have, the definition of document in General Clause Act, all the parts of a document, guys. Next, marginal notes or preamble or explanation or definition in internal aids. So internal aids, I have picked 4 ones. What is the 4 ones? Marginal aid first. If I go to marginal notes, marginal notes basically says, these are summary in the side of the act. We should not use this for purpose of construction. It should not be used, not part of the enactment, should not be used for construction. What is preamble? Preamble is in the beginning of the act. It gives the scope, object and purpose of the act. Why we have this act, guys? Preamble is part of the act and therefore we can use it for construction purpose, guys. Next, explanation. What is explanation? Look at this. In explanation, follow within the act when sometimes for some provisions they give explanation. For example, in section 42, private placement, for the limit of 200, they will tell 200 includes each type of security separately, So explanation is to understand the meaning of the section better. It has to be read along with the section. If there is confusion, section will override the explanation. Explanation cannot widen or reduce the scope of a section. So look at this. It has to be read in harmony to clear the ambiguity of the main section. It should not be construed as to widen the ambit of section. It cannot widen the ambit of section, guys. Next, harmonious construction. Preamble is done, explanation is done, marginal notes is done. Next, harmonious or reasonable construction. Follow. Harmonious construction says you have to read the entire act together. If at all there is any conflict, try to solve both. Mom is saying come home by 9 p.m. Dad is saying come home by 8 p.m. I will come home by 8 p.m. so I can solve both people's rule over there. So and they're saying if there's a specific provision, that specific rule will override the general rule. But mostly if there is a conflict, try to sort the conflict, try to follow both the provisions. For this, how do I know what's specific, what's generic? We look at three terms like subject to, notwithstanding, and without prejudice. Subject to means, for example, the later will prevail over the former. So I will follow this subject to something else. So what something else that will prevail over this. Notwithstanding, whatever is there in this only will prevail over everything else. It's called a non-obstante clause. And without prejudice means without affecting. It means without affecting other sections. So particulars of provisions will operate in addition. That means I will follow this, at the same time I will follow something else. So without affecting some other section I will follow this also. So this is the difference between these three terms, which is for harmonious construction. What is beneficial construction? Beneficial construction means nothing but reasonable construction, but the reasonableness is done for benefit of some section of the society. Look at this, to give it to some underprivileged people who have not been treated fairly in the past. For example, they will tell for farmers, I have to give this much money, but they don't have bank account. Law is saying give in bank account. I will deviate for a benefit of them. I will deviate and give them in cash. Are you following, guys? So you are allowed to do a reasonable construction, deviate from the law for benefit of some section of the public who did not get the benefits in the past, guys. That is my reasonable and harmonious construction or beneficial construction. Exceptional construction, very, very, very important for exam this time, guys. You all know what is exceptional construction. That's a case where sometimes may is read as shall and sometimes and is read as or. Opposite, shall is also read as may and or is also read as and. Here what they're saying, mandatory means you definitely have to do. So what comes in mandatory? Shall will come and will come. What will come in directive, which is optional, or will come here, or may will come in directive, guys. Now here what is important, sir? I already know this. Why are you saying this? Something which I already know. Here in my view what is important is there are 3 points where may is read as shall, when may becomes shall, and 3 points when shall is read as may. These 6 points are important, guys. You need to mug up these 6 points. No other option. When may is read as shall, the option coupled with an obligation, or may is used as a conventional courtesy purpose. I used may, or it's going to defeat. If I read as may now, provisions will be defeated. Key points. When mandatory becomes optional directive, if it's used against the government or intention of the law demands the same, or giving it mandatory, it will be very absurd. It will read in a bad interpretation. Okay. So this is basically your exceptional construction. When may is read as shall as may. Hayden's rule. If Hayden's rule come in exam, you have to write these 4 points, guys. So this exceptional construction, adjustum generis. Hayden's rule, yeah. You have to write these 4 points. These 4 points for Hayden's rule. Hayden's rule basically is also known as mischief rule. If there is any loophole in the act, how is the law trying to protect the loophole? Has the amendment, ensure the loophole is not there anymore. What was the law before making the act? What was the defect in the earlier law? How is the parliament seeking to resolve this defect? What are the true reasons for remedy? Is there a remedy coming in? After doing amendment also remedy has not come, then court will deviate to ensure the remedy is given. The court shall make construction that will suppress the mischief and advance the remedy for people who are trying to continue the mischief case. This is the Hayden's rule. Dictionary or foreign definition or earlier or later law in external aids. Let me go to external aids over here. Yeah, in external aids, if we go here, dictionary definition. First they are saying look at section 2 of the act. Try to follow definitions in section 2. If there is no word is defined there, then you can take general definitions of what is there in dictionary. Foreign decision. Can I follow foreign decisions? Yes, Solomon versus Solomon. But they are saying first try to see if there is Indian case law for that. Not there are. Then you go for foreign case law. But which foreign case law I can take? They are saying take the foreign case law from the same jurisprudence which has similar law as that of ours. So whoever has laws similar to ours, we have to take that. So I'm done with foreign and I'm done with dictionary. Now earlier and later law I just finished over here. Earlier and later law, if you see here, always the later will override the earlier. Lastly, dictionary definition. There are two types of dictionary definition: ambiguous definition and definition subject to contrary context. Let me explain this. Ambiguous, not confusing. If it is confusing, then they're saying try to read in light of the other provisions of the act. Read along with the entire act, then you will be able to understand. Definition subject to contrary context means based on which context it is used, the meaning will differ. When a word is defined to mean number of inclusive meanings, it has to get the sense from ascertained from the context where it is being used. Okay, each context it will vary. Okay, for example, plant and machinery. The word plant has different meaning with machinery, and plant separately has different meaning. That only is. Lastly, doctrine of non-sectare sources. Again, secondary rule. This also I have told it's important. Non-sectare sources means when there are two words, they have to be read together. They have to be read together, guys. When there are two words, we will read them together. And that means they're trying to say each word will take the color from the other word. Look at this. When two words are associated with each other, give them a combined meaning instead of a separate meaning. So they use the word and they couple together, understood in cognate sense. The key word here is, for exam, to get full marks, they get their color from each other. That is the important point over here. With this, I'm done with iOS expected question revision. At least run through these things and also ensure you're aware of the Latin terms. Okay. Next, let me go to next set of General Clause Act revision. Now, when we look at General Clause Act, guys, what are expected questions here? Three definitions I am giving as important over here: immovable property, affidavit, and good faith. Let me quickly go and run through this. Immovable property, if you see, guys, it has 4 points. If you write all the 4 points, you will get 3 or 4 marks depending upon how much question it comes. Immovable property shall include. Shall means these 4 are immovable property, whatever said and done. First, land, benefits arising out of land, trees, water, all of that. Things attached to the earth like buildings, etc., and things permanently fastened to anything attached to earth. For example, windows is permanently fastened to anything attached to earth, guys. So if this comes in exam, they will either ask you directly what is immovable property and ask you case study below that. Is fish immovable property? Yes, fish is an immovable property. Like that. Are you following, guys? So what are the 4 points over here? You have to mug up, no other choice. Land, benefits arising out of land, things attached to earth, and things permanently fastened to anything attached to land. Basically, if I take tree is an immovable property. Mangoes in a tree is an immovable property. But once you pluck the mango, it becomes a movable property. Next definition, let me go to good faith, guys. Good faith definition, if you see, a thing shall be deemed to be done in good faith. A thing shall be deemed to be done in good faith. In fact, if it is done honestly, whether it's done negligently or not, they're only testing honesty here. They are okay if you are careless. But however, when this comes in exam, they will test case study. Good faith as per General Clause Act gives the benefit to the buyer. But as per Indian Contract Act, a honest purchase made carelessly without making proper inquiries cannot be said to have been done in good faith. Therefore, Indian Contract Act will override General Clause Act when it comes to good faith definition, guys. Good faith is done. Affidavit, nothing to be done except mugging up if it comes in exam. The same definition we have for affidavit, same definition you have for oath, and same you have for swear. Affidavit with grammatical variation and cognate expression, meaning however I say, crying, in whatever language, with whatever tone I say, include any affirmations and declarations made by persons allowed to declare or affirm in law, guys. Important definitions. Beyond this, if you want to learn one more definition, guys, additionally, I used to tell document over here, but because it was tested in latest JAN exams, I have excluded document in our expected questions list. Next, the serving of post and date of hearing when court is on leave. All this will be there in our key provisions, guys. I have a key provisions in our book where at least these key provisions you have to learn. So look at this. These both key provisions you fully learn, but expected questions, what I am saying, meaning of service by post is important. In many times in Act you have seen, we have to send by registered post. What do you mean by registered post? Registered post means it has to be properly addressed, prepaid, stamp must be there, and posted by registered post. If these 3 are there, that means you have sent by post, guys. Then significant case laws based on this. First they are saying, sir, registered post is not the same as registered post acknowledgement due. Both are different. Next, where a notice is returned by tenant with an endorsement of refusal. When I send notice to the house owner is not there. Tenant accepted and rejected that notice. Then it will be assumed that the notice has been served only. Then lastly, look at this. When notice is sent to the address available, that means it's properly served. Whether I am there in the address or not, I don't care. Aadhaar card address is there. In that address, what is there? I have sent the notice. That's it. My work is done. Where notice and registered post to person concerned that proper address is deemed to be served upon him in due course unless the contrary is proved. Okay, unless the address is changed. Department did not update the address even after I told him to update. Then department fault. Otherwise, whatever address with department is there, if it's sent there, it means it's valid. When court is on leave or any official working day is leave, look at this. That is the next point that will be coming over here. Computation of time, any legislation. Simple terms, what is it? Where due date as per law falls on a holiday, court is on leave. The due date shall be deemed to be extended by 1 day on which the authority is next open. That means when is the court next open? It's not next day or preceding day. Next to working day or next to day when authority is open, guys. Section 19, official chiefs. This will come under over here, official chiefs. Yeah, official chiefs and subordinate comes under powers and functionaries. If you look under powers and functionaries, there are 6 sub points, guys. In expected, I'm taking only officials, chiefs and subordinates. A law relating to chief or superior of office shall apply to the subordinate. That means if something is applicable to commissioner of income tax, it's applicable even to his subordinate assistant commissioner. Next, definition of financial year or government or commencement or official gazette. Few more concepts are important here, not the definition itself. Sir, what is the definition I'm talking about over here? First, I'm talking about government. Government includes both central and state government, and government means 3 things: law, legislative, executive and judiciary. Legislative, executive and judiciary, guys. These 3 things are included in government. Okay. Next, these are the 3 lines we have studied in school days, and the line will be there. Those lines only are this. So that is basically government. Financial year, 1st April to 31st March. That's it. Year means what, sir? Year in this act is nothing but year as per British calendar, Jan to December. What do you mean by commencement and official gazette? First, official gazette, like how you have today Instagram where you put updates. Those days official news comes in official gazette. Today also it comes in official gazette. Not many people are aware. So it's basically a public journal, authorized legal document by government, where all the official updates of government comes in that. It is published weekly by official notice. By which department it's published, sir? The Ministry of Housing and Urban Affairs. Sir, what is this commencement? When law is coming into force? Simple. If a date, generally it goes to Rajya Sabha, Lok Sabha, and then President signs it. When the law is coming into force, the date mentioned in the notice. If there is no date mentioned over there, then date on which President signs. So commencement is basically when a law is coming into force, from which there is new rules applicable. Under the 2 points, where no date is mentioned, it's the date on which President is signing. If any specific date is mentioned in official gazette, then we will go ahead with that specific date. So I have done with financial year, government and commencement. Next is section 23, provision as to making rules or bylaws. Very, very important, guys. Section number 23 can be a direct question for 4 marks. 26, sorry, provision as to offense, 23 only, here it is. In our book I kept in the ending. Yeah, 23, provision for making rules or bylaws. Here there are 5 points over here. Please memorize these 5 points. Basically what these 5 points are saying, guys, if you are making a new law, no, first you make a draft, have a study circle, or like how study circle have a group of people, they will make a draft. That draft will be published, and then they will get comments. Take those comments, make those changes based on feedback, and send to other departments like income tax department, other statutory departments, get their comments also. Then once you get their comments, make another final draft and put it in both house of parliament. Once it goes to both house of parliament, it will be passed and then it will come in official gazette. Basically how a law is published, the full process is coming over here. Run through these points, fairly easy and important. Next we have last 2, point 5 and point 7. Let me finish off point 7, which is effect of repeal or offense under 2 or more enactments. Then only section 26. What is section 26 saying? Sir, I made a mistake, sir. I am accepting. For that mistake, you can't repeat the mistake. You can repeat also. I am not talking about repeating mistake here. That's why I brought it up. This is about one mistake. You can't be punished twice. So you can't be, look at this, but shall not be punished twice for the same offense. So if the offense is same, then you can't be punished twice. However, if it's two offense, sir, murder and kidnap, under the same charge sheet I have murder and kidnap. If it's distinct and not identical, then this provision will not apply. If it's two different offenses, you can be punished twice. Okay, next. In two alternate charges, sir, there is murder and kidnap, sir, on me, case on me, murder and kidnap. Murder I didn't do, sir, it's proved I didn't do murder. Then does not mean you didn't do kidnap also. So they're trying to say the same trial, the accused of one will not bar conviction of the other. Just because you're innocent in one case, sir, does not mean you're not guilty of the other case. So what is conclusion of two or more offense here? First point, article Constitution of India says what, guys? It says you can't be punished twice for the same offense. For same offense, if two different act has punishment, SEBI and Companies Act, court will decide which one to give, but only one punishment. Second, if they are different punishment, distinct and not identical, then this provision will not apply. And lastly, if there are two alternate charges, just because I am innocent in one does not make me guilty of the, or does not make me innocent of the other one also. If I am innocent in one, does not make me innocent of the other one. Each case has to be proved separately. This is in two or more enactments. Effect of repeal, very important. Again, this can be a direct question, or nowadays they are asking case study in latest RTP. Effect of repeal, 4 marks comes, you have to write all of this, or it can be case study. What they are basically saying, when a new law comes, it will not affect the old law. So affect any inquiry, litigation or remedy. Anything pending in the old law will continue as it is. It will not affect any penalty. Old penalty in VAT will continue in GST if you already have to pay. Affect any right. Previously whatever rights you got, like for example input tax credit, that will be carried forward to the next act, will not be removed. Affect the previous operation. Whatever done in the previous act is still valid. From now what you will do in the new act will be valid. And revive anything not enforced. Just because I bring GST does not mean VAT. So let's look at this. What they're trying to say, by repealing one act, but if I remove GST today, does not mean VAT will come back. So removing GST means removing GST only. So effect of repeal means when you remove an act and replace with something else, what all happens? These are the 5 points. Please go through. I've given here along with examples also. Okay. Lastly, these are the important sections which I have given over here, guys. 9, 10, 11, 12, 13. Let me go through these sections now. Okay. Yeah, after definitions, all this will be there in key provisions. 9. What is 9? Commencement and termination of time. Commencement and termination of time basically says when the word from is used, then don't count the day. Dividend should be declared within 30 days from today. Then don't count today, count 30 days from tomorrow. When I use the word to, I have to include the word for to. It shall be filed to, let's say to Sunday. Then until Sunday I will count. That is section number 9. Basically all these are important provisions that I have in the material itself. I will call this as key provisions. Remember these concepts in the computation of time. Just now we saw that court next working day. Section 11, measurement of distances between two places. How I will measure distance using straight line on horizontal place. Next, horizontal plane. Section number 12, prorata. What is prorata saying? Dividend to be declared. Let's say for every 10 shares I am giving 1 rupee dividend. Then I have 9 shares only. Compute proportionately. They are saying whenever you can't pay whole, you are allowed to compute proportionately across the law. Next, section 13, gender and number. This came in September exam, guys. Masculine includes feminine, but if law is specifically saying, this assumption cannot be made. Where law says here it includes only women or gender male, then we cannot tell masculine includes feminine. And lastly, singular shall include plural and vice versa. This is the last section 13. So I have covered 9, 10, 11, 12 and 13. And lastly now, newly I have added in the expected question list is section number 8, guys. If you ask me, I am going to end our list. Yeah, I am going to end our list with this question. But my expected question is section 8, guys. Okay, so expected question. It is section number 8. It's going to be this one. This basically says, look at this. This talks about, in simple words, where an act refers to provision in Act Y, and Act Y has been what to say, replaced by new act Y, then it refers to the new act. For example, simply I'll give example. We have Income Tax Act 1961. In Income Tax Act 1961, they will tell compute net profit as per Companies Act 1956. But now what has happened? Companies Act 1956 is not there, which is replaced by new Companies Act 2013. But the words in 1961 Act still refers to net profit as per Companies Act 1956. But 1956 is not there, no. It replaced with new Act 2013. So this provision, section 8 says, whenever such kind of a new act comes, when 1961 Act talks about Companies Act 1956 and that act is repealed and replaced with 2013 Act, it is deemed that this 1961 Act is referring to the new act. Look at this. Where an Act X, income tax, refers to a provision in Act Y, Companies Act 1956, Income Tax Act 1961, and the provision in Act Y has been replaced by Act Y new, 1956 replaced by new Act 2013, then it is deemed that Act X, old Income Tax Act, shall refer to the new Act, even if the wordings in the old Act is not yet changed. I gave an example also over here. Go through this case. With this, we are done with General Clause Act, expected questions revision. Let's proceed to the next one. Let's start off with LLP now, guys. LLP, if you see, I have made some beautiful notes for LLP, guys. Full syllabus I have given, like just 30 concepts, concept wise, simple, easy notes. If you watch the LLP class detailed, it's still available on YouTube if you want. Now come to our LLP notes, expected questions. First is contribution, section 32 and 33. When it comes to contribution, like how in a company the shareholders contribute capital, like that in a LLP, the partners contribute to LLP. In what form? Tangible, movable, immovable, promissory note, in any way they will contribute. And they can also sometimes, like how in Companies Act we have guarantee company, here they have an obligation to contribute in the future. Okay, account all contribution of partners in LLP. In the name of how capital account is there, whatever member gave will come in capital account. In LLP, whatever partner contributed will be shown under contribution by LLP for the contribution by partner for the LLP. The third party or creditor extending credit to LLP based on above obligation can use this guarantee. So third party can rely on this contribution for his security and proceed and give some, what to say, give some guarantee or let's say give any credit limit. Next, section 15 to 17, name clause provisions of LLP is fairly important, guys. I have summarized all the name clause provisions of LLP over here. Look at this. What are the name clause provisions? In fact, when am I recording this? Look at the time. It's 3rd May 8:14 only when I'm recording this, guys. It's not like some recorded thing. I'm doing it now and I'm giving it to you, guys. Okay. Name clause related provisions. Use LLP or limited liability partnership along with the name. Then the name should not be undesirable. It should not be identical or too nearly resembling name of an existing company, LLP or registered trademark. But the name can resemble a registered or unregistered partnership. This is the amendment area which they can test. So LLP name can resemble partnership. Name reservation. Once you apply, it will be reserved for 3 months. Rectification is just like section 16 of Companies Act. When you apply for when the regional director orders you for rectification, they will order you to change within 3 months. Once you change within 3 months, you would intimate ROC within 15 days, and then ROC will give you new certificate of incorporation within 30 days. The same provision is there in Companies Act and over here. That's why I keep saying foreign company LLP, learn in the last case, depending upon when here in order also, but you will normally learn in the ending. Next, application to regional director within 3 years. If somebody wants to complain about you for changing the name of LLP, they have to complain to RD within 3 years of incorporation of the company. These are name related provisions, guys. Liability of partner and liability of LLP, section 25 to section number 27. I would have given this towards the end of our chapter, guys. End of our chapter, yeah. In notes, look at this. Beautifully I would have given liability of LLP, liability of partners, case, when they are liable, when they are not liable. Liability of LLP, when they are liable, when they are not liable. When are they liable? LLP is liable if partner is acting with an authority. For doing something, partner has authority, he is doing it, even if it's wrongful act or omission, even if it is carelessness in the ordinary course of business, LLP will meet the liability because he has authority to do that. Any wrongful act or omission will be taken care. When LLP is not liable, partner is doing something for which he does not have authority. So partner doing something for which he doesn't have authority, then LLP is not liable. And if the person knows he has no authority or does not know or believes him to be a partner, they are saying it doesn't matter whether third party knows he's a partner, does not know he's a partner, whether partner himself knows he has authority or not. I don't care about anything. What they are saying, partner did something for which he does not have authority, then LLP is not liable. Opposite of this only is liability of partner's case. Basically, when partner is not liable, partner is not liable whenever LLP is liable or other partner is liable. Look at this. Partner is not liable for obligation of LLP. Whenever LLP is liable, I am not liable. And partner is not liable for obligation of other partners. Whenever other partners are liable, why should I be liable? When partner will be liable for things which he has done, he has authority in ordinary course of business for wrongful act or omission of himself in ordinary course of business, or even beyond his authority. If he has done something, then he becomes liable, guys. Okay, very important. I have given you notes over there. Unlimited liability in case of fraud, section 30. Let me explain here itself. In section 30, generally LLP talks about liability is limited, but however in some cases liability becomes unlimited in case of fraud. Liability of members personally liable, unlimited liability. Filing of annual return and declaration of solvency, next important area. Let me show you that, guys. Okay, one of the initial concepts, yeah, here it is. Financial disclosures, all the three have brought together. First, LLP has to maintain books of accounts in what basis? Cash or accrual. They allow both cash and accrual double entry registered office, guys. Accounts central government may exempt for a few companies. Next, if I see, statement of account and solvency will be filed within 6 months from end of financial year. This is like my section 137 in Companies Act, filing of FS. Annual return is like my 92 of Companies Act. This will be filed within 60 days from the end of the financial year. 60 days from end of financial year, guys. Simple. Annual return 60 days from end of financial year. Because we don't have AGM, so 60 days from end of financial year. FS will take time to prepare. That's why 6 months from end of financial year, guys. Okay. Next, filing of return is done. Partner by holding out, let me explain here itself. Who is a partner by holding out, guys? Somebody who's not a partner, but is acting or behaving himself to be a partner by estoppel, partner by holding out, and other partners are affirming or giving confirmation of such behavior, then we call it as partner by holding out, guys. Next, small LLP, just like how we have small company, small LLP limit is important. In company we had capital, which is basically 4 crores, and turnover we had 40 crores. In company we'll have 10 crores and we'll have 100 crores. Same thing over here. Instead of capital we'll have contribution over here. So I should not strike it. Contribution is the important one. Contribution up to 25 lakhs, turnover up to 40 lakhs, and this 25 lakhs can go up to 5 crores and 40 lakhs can go up to 50 crores. So there it is 10 crores and 100 crores. Here is just the half, guys. Just the half. 5 crores and 50 crores is the upper limit. And here if you look at this, guys, 40 lakhs and 25 lakhs is turnover and contribution. So small LLP limits, be careful. Separate case study question can come. They might confuse you with small LLP and small company limits. Concepts related to designated partner, very, very important. Let me close with that. Okay, designated partner points. I have given simple concepts. Yeah, look at this. Designated partner. First, every LLP must have at least 2 designated partners, mandatory, and one of them must be a resident. I know this, sir. Designated partner should be only individual. No, it can be individual or it can be body corporate. So look at this. I need to have 2 DPs. One of them must be a resident who stayed in India for 120 days or more in preceding financial year. Who can be DPs? It can be individual, it can be body corporate. I hope you're all following with me. Okay, if it's body corporate, then nominee will be individual, nominee of the body corporate. That means 2 body corporates itself together can start LLPs and they can keep 2 nominees. In that, one nominee should satisfy the 120 days condition. Come down. What are other points, sir? Key points from the entire act. Summarize like bullet points for you. Bullet, guys. DP has to give prior consent, and then if he leaves, appoint new fellow within 30 days. Ponana potunda, appoint somebody in 30 days. Okay, next, that's how life is. If somebody leaves in your life, what you have to do? Find somebody else, find a partner in 30 days, guys. Act as if is saying, if no DP is appointed, and if partners, whoever is available is deemed to be designated partner, LLP has to intimate ROC also in 30 days after you appoint the new DP. Designated partner terms defined in LLP agreement will define the terms. He has to obtain designated partner identification number. What is DP liable for? DP is liable for, responsible for all the legal compliance of the act. If not, what is the punishment? Look at this. Entire LLP, whatever is the punishment for DP, I have fully given over here. So with this, basically, less than 2 DPs now, what's the punishment? Failure to give consent to orders in 2 days now, what's the punishment? Vacancy of DP not filled now, what's the punishment? Okay, LLP notes are one of the best notes I have done, guys. If you have time, go through those notes, available in the free resource on our website as always, guys. But quickly, with this we're done with LLP. Let me go to FEMA, and with that, other laws will be done and dusted, will be done itself with the entire revision itself. Hi guys, let me brief when it comes to FEMA over here. When it comes to FEMA, guys, I'm just going to quickly brief what is going to come for 10 marks. Of course, for FEMA, I want you to go watch the main marathon or the Gen Z marathon, which will anyway be followed in this video itself. You don't have to go anywhere else. I will add it in the end. Okay. Sir, why am I doing this? Just to save time, because I have to again merge these videos. The time now is almost 10 PM today after your accounts exam. It will take me another 40 minutes to merge and upload this, guys. So that's why I'm just trying to save some time in 1 or 2 chapters. But let me mark what are those questions, and then your Gen Z marathon will start. Detailed concept of residential status. Don't skip anything in residential status, because it's a cumulative learning. Learn everything. Give importance to those 3 purpose points. 10 marks, definitely it will come. Current account schedule 1 and schedule 2. Very, very important, guys. Schedule 1 is what is prohibited. There will be some points like this dividend balancing, export of tea, then lottery tickets, outside sweepstakes, magazines, banned magazines. Now you remember these things, and limit. Schedule 2 talks about 2,50,000 for gift, for abroad education, foreign treatment, all that we can take. Correct? Mandatory to learn. Very, very important. Don't skip this. Transaction prohibited by RBI, very important. South Korea, you can't enter. Then other chit fund transaction, Nidhi company concepts we have over there, guys. Those things also are very important. Don't skip that. Then current account, other than those four cases where RBI permission, that getting donations in other country, then consultancy services, all those points, consultancy, donation in other country, those 4 points of 4 limits just came in Jan, but can repeat. Little less important compared to other points, but quickly have a read. Next one, very important point we have, concept where PRIA can hold asset when purchased or inherited as PROI, and opposite PROI can hold asset. If you remember this, a PRIA, I can hold asset in Australia if I acquired it when I was in Australia as a PROI, or inherited from somebody in Australia, or somebody in Australia can hold an asset in India when he was a PRIA or inherited from a PRIA. Very, very important. This can come in combination with limits, guys. And last one more thing, central government approval, where you need for cultural tours, sports, all of that with central government approval. There also we only have 2 limits. One is for sports tournament outside India, and PSU limit for tourism and bidding point, bidding all of that. These 2 are important, guys. Okay. Then this time for May 25 RTP question, remittance of salary under deputation, provided job does not exceed 3 years. If the job should not exceed 3 years, then you can remit, but except here, Pakistan point will be exempted. If Pakistan people cannot remit the salary back, other country people working in India can take the salary back, provided the job contract is not more than 3 years, guys. So these are the concepts. Everything I would have covered in Gen Z, guys. It's going to start right away. Go enjoy that. With that, we'll be done with expected question marathon. Thank you. We are going to quickly revise all the limits that we have in FEMA. Gen Z notes of FEMA, guys. Basically, except for residential status in FEMA, we are going to revise the whole of FEMA in the next 10 to 15 minutes max. Basically, if you see, there are 7 dabbas that you have to remember, or 7 different types of limits. First is current account, which is schedule 3. Current account has totally 3 schedules. The third schedule talks about what you can do as an individual. For that, as an individual, limit is 2,50,000. If it crosses that, then you will go to RBI. This 2,50,000 is for what things? Like gifting, for donation, for any expense of medical, education, private tours, tourism, all of that if you want to go abroad. In that, they are not giving you 2,50,000 if you go to countries like Nepal and Bhutan, because you can use Indian currency itself. In this list, specifically they are saying for immigration, medical treatment and studies. For these three things, if it crosses 2,50,000, please get a confirmation letter from the respective institution also. Now, this 2,50,000 is for one individual. When I go with a group of friends or family, can I group it? Yes, friends, family. Same if you go together in the same visa or same visa, you can group it off, guys. Okay, that is about schedule 3. These are the key points. Other expense of schedule 3 could be, for example, you are buying mobile from US. Okay, you can buy mobile from US. It should be within the limit of 2,50,000. Are you following, guys? Clear? I'm not capitalizing mobile, keeping it in the expense side. Next, again within current account, schedule 1 is prohibited. That means current account has 3 schedules, guys. If you look at the 3 schedules of current account, should you remember these numbers? Yes, I will tell. Yes. Okay, easy to remember, nothing great. It's easier than section numbers. What is schedule 3 of current account? Which you can do, allowed, permissible. Can do means permissible. Okay. Next, schedule 1 is cannot do, prohibited, no permission, nothing, you cannot do. Schedule 2 is you can do with the permission of central government. Schedule 3 is can do with the permission of RBI. Are you following? Within schedule 2 you have 2 types. One is for individual, one is for other than individual. What we finished so far is other than individual. So we are individuals. We are done with individuals for schedule 3. Next is current account, schedule 1, prohibited. These things not allowed. Remittance out of lottery winnings. All lottery winnings in India you can't remit out. Racehorse winnings, riding horse from India, money can't go out of India. Money can't go out of India. Remittance for purchase of lottery ticket outside India, US lottery, no. For abroad, then banned and prescribed magazines you can't buy. Football pools and sweepstakes outside India you can't buy. Next, this same list has few other things. You have to search for these terms. Now I'm not focusing on logic in detailed class. Here, callback service, dividend balancing, commission on export on equity investment of wholly owned subsidiary in India, special rupee scheme account. These are all in schedule number. Which schedule, guys? 1 which you cannot do, current account. So out of 4 dabbas that we have in current account, 2 we have revised. Are you able to follow, guys? Okay. Next, one more point we missed here. Commission on exports up to 10% of invoice value for tea and tobacco. Usually you can't pay commission on exports, but if it's for export of tea and tobacco, allowed up to 10% of invoice value. This also is what in cannot do, with one exception. You can do up to 10%. Clear, guys? Next, I'm going to current account schedule 2. Schedule 2 of current account, which is generally for the government departments, PSU, institutional level, government, usually for government departments or government things. Central government, you have to get approval for all of this. Cultural tour. Is there any limit for cultural tour? No. Cultural tour, you have to get limit approval. Cultural tour. Freight of vessel by PSU, then that means renting of ship by PSU. Import by PSU through ocean if there are some expenses. Multi-model, here again code word, multi-model. Then container detention and payment of PNI club and transponders. Are you able to follow, guys? For this we had that story also. Indian team going to West Indies, that ship, signal, all container, all that is done. In this central government approval, apart from these code words, multi-model, container, all of that, okay. 2 points have limits. So you have to remember this for sure. If it's for payment to foreign print media by public sector undertaking, you have to see, is it for the following set purpose: tourism, foreign investment or international bidding, then it is exempt. Others na up to 10,000. So if PSU is advertising for 3 purposes: tourism, foreign investment or international bidding, then allowed. Beyond that, others up to $10,000. Prize money for sponsorship for sports that happens outside of India. Any state or national or international body of India is conducting cricket tournament, badminton tournament, whatever tournament, there is no. Apart from state, national, international, private is conducting up to $1 lakh is allowing. $1 lakh into 80 is close to 80 lakhs. That's the for keeping cricket tournament for private company. So they're allowing up to that much. Are you following? Now we are going to schedule 3, current account other than individual. So if I come back to this diagram over here, now we have finished revising schedule 1, what you cannot do. Schedule 2, central government is done. Schedule 3, we have finished with individual. Now we are going to schedule 3, can do with RBI permission for other than individuals. In other than individuals, there are only 4 points, and all these 4 are important limits. Okay, I told there are only totally 8 limits in this act, correct? Only 8 limits with some schedule numbers. You can't remember this. If you look at the past exam question, this only they are testing. These limits will come for 4 or 5 marks. Now, commission to an agent abroad for sale of residential or commercial plot in India. So, let's say you are selling residential or commercial, your house in India is purchased outside. For that, for agent commission is $25,000 or 5% of inward remittance, whichever is higher. Logic is more higher, more commission you will get. Consultancy for infrastructure up to 1 crore, $10 million. Others 10 lakh, $1 million. Following, guys, clear? Next, reimbursement of pre-incorporation expenses, that is allowed up to 5% of investment in India or $1 lakh, whichever is higher. This you have to mug up, but the logic you know, why higher, why lower. Last one is a new point, donation. Very, very important for exam. If you are donating for 3 purposes, code word, chairs for chairs over there, or funding of educational institutions or any funds for educational purpose, or technical institution for research in the same field of donor company, then in that case, it will be 1% of forex earnings of last 3 years or $50 lakh, whichever is lower. This ends our current account 4 dabbas. Not that difficult to remember, correct? Half an hour before exam you go through that 1.5 day, you can revise. Now coming to capital account, much more easier. What is capital account definition? We saw capital account is basically a person resident in India alters asset, liability, contingent liability outside India. Person resident outside India alters asset liability in India. For that, examples only are in schedule 1 and schedule 2. Not that important in capital account. That's why we didn't write here. Meaning simple, fairly easy list. Giving loan, taking loan, buying asset, selling asset. In schedule 3, there are some prohibitions. That is more important for capital account because things to remember. North Korea, can you enter into transaction? No. Who has to give permission? Central government. If you enter into transaction, buy asset, sell within 180 days. Then for a PROI, is prohibited to invest in India, even though we are getting forex, chit fund, Nidhi, agriculture and plantation, and real estate, TDRs. You can't invest. TDRs is transferable development rights. But the word real estate does not include this. That means these things are included. Commercial and residential flats you can invest. Real estate in infrastructure trust you can invest. Township, roads and bridges they can invest because that is for development. Otherwise, how will we develop? These are basic developments that are needed. Lastly, some miscellaneous concepts we saw, where apart from the limits, apart from residential status, what to remember. In reverse, if you see this account like RFC, resident foreign currency, or EEFC, exchange earners foreign currency, balance will be in dollars. These are exempted from FEMA because it's in dollars. Next, if any foreign national is working in India and getting salary, he can take the money and go abroad. Remittance of salary of non-resident working in India for the job should be maximum 3 years, but Pakistan means you can't take the money. Then under definitions, foreign exchange definition, you know what is foreign exchange. Balance in bank account in foreign countries. Other Tandi he is saying, any instrument like traveler's check or bills of exchange drawn in India but payable abroad, payable in dollars, or drawn outside India in dollars, payable in India in rupees. Between the two things, where it is drawn, where it is paid, any one should be abroad. It should be in dollars. Then also we call it as foreign exchange. So these are the concepts in FEMA. Quick revision except for residential status and related point of PRIA and PROI. Are you able to follow, guys? That's all you have to remember for exam, guys. Thank you. So today residential status lo what we saw. For exam what to remember, sir? One last time we will do and close. You never left India. You are a PR. II. You left India for 3 purpose. You are a PR. OI. I don't care about days. You left India for other purpose. I will check the previous financial year. If it's more than 182 days, yes, you are a PR. You left India for other reasons, but last year you didn't stay for more than 182. No, then you are a PR. OI. Come down. Coming into India is easy. Coming into India. 3 purpose. Yes, PRI. Others are PROI. Then this PRIA and PROI, that property purchase. Are you for? And for company you have to write last one. Residential status for company, for other than individuals. 3 points. Incorporated or registered in India or registered, simple I'll write. Okay. Indian entity, the PRII controls foreign branch or subsidiary or whatever. This also will become PR. I'll write all these are PRI. This also is PRII. And last one, PROI, let's say foreign entity controls branch or subsidiary in India. That's it. All these 3 are PRII. Second point, Indian entity PRII is controlling the foreign branch or subsidiary. Third point, PROI, foreign entity is controlling the Indian branch or subsidiary. Clear? Make a note. Anyone has a doubt, guys? Okay. Now to summarize the whole chapter, if you see, we basically have current account and capital account. Now if you see the 3 schedules, if you remember, now if you read the limits, you will understand. Schedule 1 is what is allowed for a PRII, correct? Schedule 2 is what is allowed for a PROI. No, அப்போ நான் non-resident சொல்லியிருப்பேன். Schedule 3 is basically what is prohibited. This includes both PRII and PROI. How it includes both? Schedule 3 only talks about PRII not to go have transaction with North Korea. Schedule 3 only also talks about PROI cannot invest in Indian Nidhi company, chit fund, all of that. Current account also has 3 schedules. First, schedule 1 of current account is basically what is prohibited for a PRII, mainly II, PRII is prohibited. Then schedule 2 talks about what? Wherever you need central government approval, this was majorly for those PSU entities and chartered vessel, all of that. Schedule 3 pathina, they classified into individuals, others. Individual what is permissible with the permission of RBI. For others what is again allowed 4 points, but here permission of central government, RBI. RBI. Again, what? Then same. Others also. What is permitted with the permission of RBI? Are you following, guys? Correct. We covered all the 7 schedules, guys. Limits. This is what we finished before this. Now, are you understanding? Whether you know residential status or not, limits are not going to change for you. And the schedule is for whom, you have to be aware when you're writing the answer. Done, guys. Can we proceed? Hello. That's it. With this, we are done with FEMA. Thank you. Any doubts before we close? Fine. Thank you.